Lord, under compelling circumstances, my lord, I am mentioning this matter. My lord, since September 2023, the matter is appearing before your lordship's monthly list, daily list, my lord.
Have you seen the first page of my list?
My lord, upon notice.
Have
My
you
lord,
seen the first page of my list, sir?
yes, my lord, I have seen.
You're still
But under
mentioning?
compelling circumstances, my lord, I am mentioning, my lord, let it be appear in the heading, my lord,
Not
new
appear
motion.
anywhere now, sir. It will wait. Please wait for some time.
Well, it is a very urgent matter, my lord.
All the matters
Since-
are urgent.
My lord,
Is
since
there any matter
September,
which is not urgent?
my lord, since September, my lord, it is continuing. My lord, not a single day when it was called on. And
Maybe.
therefore, my lord, let the
Please
matter,
wait for some time. I think I've
let
said.
the matter be appear under the
Please,
heading
next,
new motion,
any
my
other
lord.
matter?
My lord, under extreme urgency, 31st.
Correction,
Yes.
contempt, nothing
My lord,
else.
under compelling circumstances, I have come for
Restriction.
31st of March is the disposition and demolition of my sweet shop. The person runs a sweet shop of 200 square feet at Gorbeta, my lord. Now, my lord, 31st March, the next week is completely holiday, my lord. There is no scope, my lord.
There is the demolition notice.
Yes. It is given at the bottom, the date. Now, my lord, very surprisingly, the appeal is pending before the authority.
10-4.
No, under 62, 1962.
Yes.
62 Act, my lord. At the bottom, the date is given, my lord. 31st of March. Kindly see. Now, my lord, before that, there is another appeal pending. During pendency of the appeal, without hearing us, this order has been passed.
You're asking for leave.
So, leave, my lord, can it be taken up at today 2 p.m.?
No.
My lord, next week is, my lord, holiday, my lord.
Not the entire.
So, my lord, kindly direct to appear on 27th at the top, my lord. Otherwise, on 27th, my lord. 27, my lord. I'm grateful to you,
May I
lord.
be permitted to mention for my lord for correction, my lord?
Correction upon notice.
No, my lord, I will
Please
submit.
inform that.
I will your lordship.
For withdrawal, give the number. Please. Upon notice to the other side.
Your lordship mentioning for extension of interim order.
Upon notice.
Upon notice, your lordship.
My lord, for extension of interim order.
My lord, may I permit to mention, my lord? My lord, this is for upgradation, my lord. Is item number
Please go through
642.
the first page of my list. Please go through the first page of my list.
Sir, I am.
Mentioning is not being taken up for some time. Please wait. Yes.
But there is
Yes.
the urgency.
My
My
lord,
lord.
I read the indication your lordship list, my lord.
You have to wait for
My
some
matter is item 476, my lord. I'm asking for nothing, my lord.
My lord.
What happened, my lord? Eviction notice issued by the airport authority, my lord. If some date may be fixed in the my lord matter, so that I can inform the airport authority to wait for some time, so that the matter can be taken up by this
It
court.
is appearing.
Yes, my lord, it's appearing as item number 476. In spite of that, they are trying to throw me out from the my lord. This is a school. 5,000 students are, my lord.
শান্তনু, নাম্বারটা নিয়ে একটু উপরের দিকে রাখুন।
Lord, I am seeking lordship indulgence, lord.
হ্যাঁ, উপরের দিকে প্রথম 10 নম্বর।
This poor farmers, lord, depends on mother water, lord, for the cultivation, lord.
For some.
Only thing is, lord,
Just mention the matter.
just
So the order will not change for a senior.
I mean, just said I can clarify. I can.
Today's list, please. You have to wait. জলপাইগুড়ি সার্কিট বেঞ্চ।
Jalpaiguri circuit bench matter item number 1.
My lord, I am filing the report. To the
Report.
Yes, my lord. That is the demarcation. Your lordship was pleased to direct the PLRO to demarcate with videography. Enough. Enough.
There was a direction for fresh demarcation.
Yes, ma'am.
That has been done
Yes, ma'am. I have
in
given that.
presence of the petitioner.
Yes, my lord. I have handed over the.
Yes, my lordship, now only I get these reports. Can
Do you want to
the
go through this
matter-
and come back?
Yes, my lordship, can this matter will be pass over for
Passover will not be
No,
possible.
tomorrow, my lord, your lordship can fix the matter. Oh, tomorrow. No, my lord. Then another date, my lord, has become there is some holiday is there, my lord. Monday.
Yes,
Tuesday.
yes.
So, my lord, after 15 or if he wants to see, my lord, he will see that. My lord, if your lordship will see my report, my lord. Totally, my
I'm
lord.
seeing when can first week of April এ ফেরত আসবেন আপনি?
my lordship 3rd of April.
3rd of April. Very well. Is it there?
Yes, my lord.
Because since she travels from Jalpaiguri,
Yes, my lord. I have nothing to say, my lord. Your lordship can
demarcation report submitted on behalf of the alleged contemner is taken on record.
My lordship, now can this hearing can we make today? My lordship, I'm ready.
You're ready? Yes, make your submission. Just wait for me. আপনি যদি এটা দেখে ফেরত আসতে চান আপনি করতে পারেন।
My lordship, demarcation হয়েছে my lordship.
হ্যাঁ।
This demarcation done in 12th of March 2024. সেদিন শান্তিপূর্ণভাবে ডিমার্কেশন হয়েছে। বিএলআরও স্যার নিজে এসেছিলেন, আইসি স্যার কিছুক্ষণের জন্য এসেছিলেন অ্যাজ ওনার অনেক দায়িত্ব
আপনার
আছে।
প্রবলেম সলভ হয়ে গেছে, তাই তো?
My lordship, demarcation done. My lordship, not accurate position. They give my lordship ঠিকঠাক একেবারে ঠিকঠাক বোঝায়নি, কিছুটা আছে জায়গার মধ্যে মেজারিং এর ওনারা যেটা বুঝিয়েছেন কিছুটা 19-20 আছে, কিন্তু সেটাকে আমি আপাতত মেনে নিলাম কারণ আমার রিলিফটা এই মুহূর্তে বেশি দরকার। আর মাই লর্ডশিপ 12th the demarcation done 13th my lordship the demarcation pointing, যে পয়েন্টিং গুলো মাই লর্ডশিপ ওনারা এসেছিলেন ডিমার্কেশন করতে 12টা নাগাদ, শুরু হয়েছে 1টা থেকে 4টা বেজে গেছে। সেই দিন ওনারা ডিমার্কেশন পয়েন্টিং এ করে গেছেন। আমি লোক রেখেছিলাম কিন্তু সেই দিন কোনো পার্মানেন্ট ভাবে পাকা কিছু দেওয়া হয়নি, বাতা রেখা হয়েছিল মোটামুটি।
ওনাদের দেওয়ার কথা না, ওনাদের খালি
Yes, my
ডিমার্কেট
lordship.
করার কথা।
Yes, my lordship. But this এটা আমাকে বলছে পুলিশ অথরিটিস যে এটা আমাকে ওদিন দিয়ে দিতে, ইভেন আইসি স্যার নিজে বলেছেন যে জায়গায় দখল নেন আমরা আছি। বাট মাই লর্ডশিপ ওদিন তো শান্তিপূর্ণভাবে গেল, পরের দিনই ওনারা যার ডিমার্কেশন পয়েন্টিং গুলো ছিলেন আমার রেসপন্ডেন্টসরা সব এক এক করে উঠিয়ে দিতে থাকলেন। আমি একটা করে কমপ্লেন দিলাম পুলিশ স্টেশনে। 13th কমপ্লেন হয়েছে, 14th কমপ্লেন হয়েছে, 17th কমপ্লেন হয়েছে। 17th ওনারা কোনো মানে আমার রেসপন্ডেন্টসরা কোনো ডিমার্কেশন পয়েন্টিংই রাখেনি। ইভেন 15th ওনারা রেসপন্ডেন্টসরা পুলিশ অথরিটিস থাকতে যখন ওরা ঝামেলা করতে শুরু করে তখন আমি পুলিশ স্টেশনে ফোন করি, ওনারা আইসি স্যার পাঠায় পুলিশ অথরিটিতে, ওনাদের সামনে আমাদেরকে মারতে আসে। আমি আর আমার মা সেই পজিশনে ছিলাম।
এগুলো আপনাকে ক্রিমিনাল কোর্টে যথাযথ জায়গায় আপনাকে
Yes,
মামলা করতে
yes,
হবে।
my lordship, but
The
ওদের
contempt
এরকম
court will not deal with all this.
my lordship ওদের এরকম জিনিসটা আমাদেরকে ওই প্লটে ঢুকতে দিচ্ছে না my lordship। পুলিশ ওদেরকে আটকাতে পারছে না
আপনার
চোখের সামনে।
allegation আপনার রেসপন্ডেন্টদের উপর,
Yes, my
not
lordship.
on the alleged contemner.
No, my lordship.
So contempt application এর থেকে বেশি তো এই কোর্ট কিছু করতে পারবে না, আপনাকে প্রপার রেগুলার মামলা করে রিলিফ চাইতে হবে আপনার, কারণ এটা একটা প্রাইভেট ডিসপিউট হয়ে দাঁড়িয়েছে এখন।
Yes, my lordship.
পুলিশ অথরিটির উপর বা কোনো গভর্নমেন্ট অথরিটির উপর আপনার কোনো অ্যালিগেশন নেই, ওনারা যথাযথভাবে ডিমার্কেশন করে দিয়ে গেছে।
Yes, my lordship.
Now
And-
your allegation is against your co-sharers or your relatives, whoever are disturbing your possession.
Yes,
So
my
you
lordship.
file a regular suit in that case. And you have to pray for execution actually.
Yes, my lordship. My execution is pending and
Till
that
the execution is disposed of, I don't think any fruitful result will be achieved.
my lordship execution is pending. The next date is fixed for order. For final order, the WO's period is finished for on behalf of the
So
defendants.
please wait and see what order is passed.
Yes, my lordship.
I'll dispose of the contempt application. Contempt application আর এর থেকে ফার্দার কিছু এই কোর্টের contempt application এখানে করা হবে।
মাই লর্ডশিপ এটুকু আমি কোর্টের সাবমিশন দিতে চাচ্ছি, পুলিশ অথরিটিস জানি আমাকে এটুকু হেল্প করে যাতে ওরা এই জায়গায় ডিস্টারবেন্স
Contempt
না
application
করে।
এর স্কোপটা খুব লিমিটেড হয়, কোর্টের অর্ডারটা কমপ্লাইড হয়েছে কিনা সেই জন্য কন্টেম্প্ট অ্যাপ্লিকেশন, রাইট?
ইয়েস মাই
আপনি
লর্ডশিপ।
তো এতদিন ধরে কোর্টে মামলা করছেন, আপনি এইটুকু আইন বুঝতে পারছেন।
ইয়েস মাই
সুতরাং
লর্ডশিপ।
contempt application, I don't think any further direction is necessary because it has been substantially complied with.
My lordship, the
Come back with a regular writ petition or a suit, whatever you feel like.
my lordship, ওই যে অর্ডারটা আছে ওনারা ঢুকবেন না, যে টাইটেল সুটের যে অর্ডারটা সেটা স্ট্রিক্টলি মান্য
Your
করতে বলেছে।
execution will be before the suit court. ওটার মানার দায়িত্ব বা whatever direction the suit court has to give. এবং ওখানেও পুলিশ হেল্পের প্রভিশন আছে, ঠিক আছে? Let me discuss this out.
Yes,
Because in a contempt application,
ma'am.
nothing further.
My lordship, the illegal construction যেটা হয়েছে সেটা my lordship
এগুলো
demarcation
কন্টেম্পট অ্যাপ্লিকেশনে ডিল করা যায় না। আপনি লিগ্যাল অ্যাডভাইস নিন কারণ, যেখানে যে ফোরামে করতে হবে মামলা আপনি সেইভাবে করুন। Demarcation report বললাম, submitted on behalf of the alleged contemptor is taken on record. Paragraph, it heard learned counsels for the parties. Paragraph, it appears that the order under contempt has been substantially complied with. Paragraph, in view of the above, the contempt application being CPA and such is disposed of. Paragraph, there shall however be no arrest to cost as in certified website copy.
my
আপনি
lordship,
দরকার হলে necessary steps নিন।
yes my lordship, my lordship 5th of January যে অর্ডারটা হয়েছিল, আইসি স্যার নিজে এসেছিলেন, ওদিন উনি সাবমিশন করেন, উনি জায়গা জানেন না বলে উনি কমপ্লাই করতে পারছেন না। my lordship, কমপ্লাইটা জানি হয় এই ব্যবস্থাটা আমাকে করে দেন না।
এইটাতে এর বেশি আর কিছু করা যাবে না, এটাতে এর বেশি আর কিছু করা যাবে না, আপনাকে নেসেসারি স্টেপস নিতে হবে। Yes, call the days list, please.
কে কালেকশন কি ডিপার্টমেন্ট থেকে?
Correction. এটা ডিপার্টমেন্ট থেকে এসেছে।
হ্যাঁ।
Seven three eight of 2012 একই আছে। 0738 ওটা 23738, এখানেও 20, এখানেও 20 করেছে। Inadvertent error has crept into the order passed on January 13, 2023. Paragraph in the said order, WPA 20738 of 2012 be read as 23738 within bracket W of 2012. Paragraph, the department is directed to incorporate necessary correction accordingly. This order be treated as part of the order passed on January 13, 2023, as in certified website copy. Next. I can do.
I do not know why this matter has come up, my lord. This matter was dismissed for
Must be
default.
some typographical mistake. I'll just find out. Huh? Number. The number has been wrongly
Fine.
recorded.
My lord, my appearance may be noted. I was also present on the last occasion when this matter was dismissed for default.
Number ভুল কোথায়? One 40804 হয়ে যাচ্ছে, জয়ন্ত রায়। Inadvertent error has crept into the order passed on 5th February 2024. Paragraph in the third paragraph of the order, comma, WPA 14804 of 2019 be read as WPA 14084 of 2019. Paragraph, the department is directed to incorporate necessary correction accordingly. This order be treated as part of the order passed on 5th February 2024 or in certified website.
My lord, my name be recorded.
Yes?
My name be recorded, my lord. I was present. I was no, no.
This is from the department.
No, I was
Correction
present.
is asked for the
I was
department.
present on 5th. On 5th, when the matter was dismissed for default, I am for the respondent. I was present.
So I cannot record your name on the for 5th. You've not mentioned it that day.
No, I did not.
Then
Since it has come today, my lord.
it's come from the department for a correction. Next matter.
The item 3, Lord, I am for the extension, Lord, 3 and 4, Lord, hearing it,
Please appear, Mr. Dev.
yes. But 3 and 4 together. It's
It's a
appearing
hearing
in the
matter.
hearing list.
Yes.
It's appearing.
Affidavits are complete.
Yes.
Heard learned counsels for the parties. Paragraph, let the matter appear under the heading Group 1 hearing on 24th April.
As your lordship, please.
Paragraph, the interim order granted earlier is extended till 31st May or until further orders, comma, whichever is earlier.
But May 31st may be a holiday, my lord. Summer vacation.
You can come on the closing date.
Before that.
Yes.
Very. Agreed.
Next.
No, I am for the petitioner,
Yes.
but this is for the extension of the interim order.
Have you served?
No. Hello?
Have you served the respondents?
Yes, yes. In all this order, they have appeared. Now, on 24th August 2023,
The private respondents.
I pointed out the three queries. Kindly see this order. They did not. 24th August 2023. I raised three queries.
Have you used your exception?
Yes, this is my exception. Kindly. And well, when the report was filed initially, they did not give any answer to my query. Your lordship passed the second order to give second report by giving a reply to these queries. Now, second report which was filed,
Let the interim order be extended for a limited period.
Let us have
Have
a
you
copy of
received a
this.
copy of that? Please serve a copy.
I don't know.
Exception used by the petitioner to the report submitted by the assistant engineer, comma, PWD, comma, Kharagpur subdivision, and the subdivisional magistrate Kharagpur is taken on record. Paragraph, let the matter appear under the heading Group 1 motion on.
Opposition reply has been exchanged. Let it to under here.
This is not an opposition. This is a report in the form of an affidavit and an exception. 25th April. 25th April. 25th April.
25th April.
Paragraph, the interim order granted earlier is extended till 31st May 2024 or until further orders, comma, whichever is earlier. Next.
That's all.
In this matter, I am for the petitioner. Interim order
You're for the petition.
was going to expire on 31st March. Madam, it was already running in the list of your lordships for hearing. Interim order is going.
I'll fix a date for hearing.
My lord, my lord.
Yes, that's the one. That I wanted to make.
Your appearance?
সেটাই বলতে চাইছিলাম যে এখন ডেট ফিক্স করে হিয়ারিং করব
Heard learned counsels for the parties. Paragraph,
What's for it
affidavits are complete.
না
Paragraph, let the matter appear under the heading Group 1 hearing on 24th April.
24th April, no problem.
Paragraph, the interim order granted earlier is extended till 31st May 2024 or until further
No
orders. comma,
problem,
whichever.
no problem. Absolutely clear order, my lord, no problem.
Next.
Mainly, my lord.
But may I submit my affidavit service? Every service.
Join the affidavit of
Fine.
service.
31st May is a holiday, madam.
Prior
আরে
to
তাতে
that,
কি
the
আছে
last working day you can,
হ্যাঁ
if it is not
সবই জানে
prior to that, if not disposed of, yes.
সবই জানে কাজ করতে দে মহিলাকে কাজ করতে দে।
স্যারের কাছে শিখেছি, জানবো না কেন?
ও, আমার কাছে
স্যারই তো আমাদের শিখিয়েছে। সব
যত খারাপ হলো আমি ভালো হলে উনি
ভালো কারণে একবারে 3 মাসে ইন্টারিম অর্ডার এক্সটেন্ড করে দিই।
Senior has to take the responsibility.
Yes.
হ্যাঁ
Senior's shoulders are much more strong.
No, no, no. My shoulder is very weak. I always try to disorder everything. ভালো কিছু হলে তখন এদিকে মানায় না, এটা দেয়া থাকলে আসে না, খারাপ হলেই বলে ওনার থেকে শিখেছি।
It's being recorded.
বলাই বাবা, না, I am telling you one thing.
Yes.
His wife, আমার খুব ফলোয়ার, কেন? I have never seen her. ওর মেয়ের বিয়েতে নেমন্তন্ন করেনি তো, জানি। ওর মেয়ের বিয়েতে নিয়ে গেল, ওর সিভিল আপনি এসেছেন, দুজন জাজ দাঁড়িয়ে আছে, মন্ত্রী দাঁড়িয়ে আছে, তাই তো আপনার খুব ভালো লাগে আর নাটক
You can file an affidavit in opposition to this if you want to. Next matter.
Lordship, I'm for the petitioner, Lordship.
দিয়ে দেবেন সব।
Lordship, the last occasion, Lordship.
My lord, in the last occasion, my lord, I pay some time, my lord.
Yes.
My lord, also I pay some time, because my lord, I request you to comply the order, my lord, but I could not contact with the.
Lordship, last 3 occasion it is going
Yes, my
on, Lordship.
Previously, my lord, I was not appointed, my lord. I was lastly appointed, my lord.
Last day, Lordship, we have
Last time, my lord, I
added
paid.
the-
After that, my lord, I requested, my lord. after
1 month.
I'm led by Mr. Gautam De, Lordship.
I'll grant the contemners 1 more month for compliance. Let us see.
15 days, Lordship. More
No,
than
no, for
3
compliance.
Compliance.
For compliance.
For compliance, let it be 1.
Yes.
Mr. De, please look into it.
My lord, I have already asked him and he issued the notice, my lord, understand?
Learned counsel for the alleged contemners seeks accommodation to comply with the order under contempt. Paragraph, let the matter appear under the same heading on 24th April. Paragraph, affidavit of compliance be submitted on the adjourned date. Next.
Before my, just a minute, Dada, ek minute. Before my matter is being taken up, she is in deep trouble because she has gone through the report and etc. And she finds there are certain anomalies are there. On her behalf, I
In
request
the
you.
report.
Yes, in the report, my lord. So I request your lordship, my lord, to kindly fix up another date. Can you recall your lordship?
You want to come back with an exception to this?
Yes, my Lordship.
Mr. De, let her come back.
Ask your lordship. আরে আমি তো কিছু বলি আমার তো
জয়ন্ত,
my lord ই তো
আপনি দিয়েছেন
ওই নাই
অর্ডারটা কেটে দিন হ্যাঁ ডিমার্কেশন রিপোর্ট থাকবে তারপরে করুন কপি অফ দ্য রিপোর্ট ইজ মেড ওভার to the petitioner in court this day. Paragraph, on prayer of the petitioner the matter is adjourned. Paragraph, let the matter appear under the same heading on weekend হলে সুবিধে হয় আপনার 5th April Friday.
My Lordship,
কথা না বলে
Thursday, my Lordship.
Mr. Pan, I would request you to, since you have
Yes,
voluntarily
কথাটা হচ্ছে
taken
যে
up
শুক্রবার হলে কি আপনার সুবিধা হবে না বৃহস্পতিবার?
Thursday. Very well. So 4th April.
4th April. Now, my lord, lordship, kindly have a look at your lordship's order dated, my lord, 20th February 2024.
Yes.
Today they are supposed
So
to
this is
file, my lord,
already-
file them, my lord, but my instruction is this, my lord, that till that I have not been paid with the money.
yes my lord. My lord, money has come, my lord, within 15 days, my lord, money will be paid.
15 days.
Your lordship. Money has come,
Mr.
my lord.
Way on the other side things
Yes,
are
yes,
better.
my lord,
My lord,
but
say, I have
this
told you,
aspect, my lord, I really respect
very
him, my lord,
sincere.
yes, I really respect him. So kindly record is the submission, my lord, that within 15 days they will pay the money.
It is submitted on, shall I take this on record?
yes my lord.
Instructions submitted on behalf of the alleged contemner is taken on record. Paragraph, learned counsel for the alleged contemner submits that the order under contempt shall be complied with in its entirety within a fortnight. Paragraph, in view of the above, let the matter appear under the same heading on
Civil sense, my lord. Civil sense, I have complied, compliance report. I must.
very well 10th April.
10%.
10th April. Next.
Item 9.
First time. কোথায়? কেউ তো নেই। None appears for the applicant petitioner. Paragraph, let the matter appear under the same heading on 5th April.
Time for the applicant.
My lord, yesterday I also filed my compliance report, my lord, because the non-availability of the petitioner, my lord, are pleased to not today.
Complied. The representation has been disposed of, I found,
Representation has been disposed, but subsequent action.
but you are not happy.
No, no, I am happy. That part, my lord, our allegation is established by the authority council, my lord.
Then what are subsequent steps for execution?
No, this
The
is,
direction was disposal of the representation.
My lord.
and my lord,
That is-
So the
that
order
is-
has been complied
That
with.
is true, my lord. That is true.
Affidavit of compliance submitted on behalf of the alleged contender is taken on record. Paragraph, it appears that the order under contempt has been complied with. Paragraph, in view of the above, the contempt application being CPN such and such is disposed of. Paragraph, there shall however be no arrest costs as is certified website.
grateful to your lordship.
Both the 11 clause.
Yes, who is appearing in this matter? No one. None appears for the petitioner. No accommodation is sought. Dismissed for default. Application to dismiss. কি application ছিল বের করুন তো? Restoration. Application to issue. Oh, writ petition dismissed earlier. Application is dismissed করুন. Can one, huh? Application to dismiss করুন. Restoration is. Next.
I appear for the KMD.
This matter, I am appearing on behalf of the petitioner, my lord. My lord, see, my lord,
Yes.
it is admitted by the authority.
Yes.
It is admitted by the authority that the land in question belongs to the writ petitioner. But the writ petitioner initially preferred a writ petition before this
Oh,
honorable court.
declare in favor of some other person.
My lord.
British Mali.
My lord.
Yes.
My lord, thereafter, my lord, I am submitting before your lordship, my lord. The KMD has filed a report. Well, before that report, my lord, I am placing the order passed by the special land acquisition officer Howrah, my lord. Or may I place, my lord?
At page.
At page, my lord, annexure, page 70, my lord. 70.
Page?
Page 70, 70 of the writ petition.
Of the writ petition.
Writ petition.
This is the order impugned.
This is the order impugned. I have challenged this order.
Yes.
My lord, may I read, my lord? My observation from official records. In LA compensation list, one Satish Mali is unknown Pakuria in whose favor LA compensation was declared in RS plot number 835 area 0.15 acre, 185 acre, Bagan, Moja Khalia Southern Side. And it was non-verified. LA compensation value rupees 99,284 through check bearing number such and such dated 7/6/2006 was given to Lanet Court, Howrah under section 30 of LA Act 1894. The check was expired and the letter was sent to Treasury Howrah from the office of the Special Land Acquisition Office Howrah for cancellation of the said check by memo number such and such 12 dated 12 July 2007. My observation from the record produced by the petition next. RSROR Shimanto Chakraborty, son of Damodar Chakraborty, is recorded owner in full share of RS plot number 835, Moja Khalia, jail number 06 PS Bali, classification Bagan, Khotian number 390. Affidavit affirmed before Executive Magistrate Court dated 23rd August 2022, Sri Gopal Chakraborty, son of late Shimanto Chakraborty, village Khalia, Post Office Chamrail, PS Rilwa, District Howrah is only one legal heir of late Shimanto Chakraborty. My observation from the ROR produced by BL LRO Bali, Jagacha White number, suggested memo number dated 12 September 2022. Authenticated ROR Shimanto Chakraborty, son of Damodar Chakraborty, is recorded owner in full share of RS plot number 835. This land. My lord, the writ petitioner is the only son of Shimanto Chakraborty.
That is admitted. No
My lord,
dispute. Yes.
my lord, next, my lord. Report dated 13 October 2020, 7 November to 14 November 2022. No person named Satish Mali, son of unknown Pakuria, was there in Khalia, and Pakuria moved just last 30-40 years as per local
This
village.
is completely in your favor.
My lord, everything
Order.
is on my favor,
Yes,
my lord.
yes.
My lord, my submission before your lordship. My lord, kindly consider, my lord, the as per report filed by KMDA. Although paragraph 4, my lord, may I read paragraph 4? That the RS plot number 835 Western of Mauja Khalia GL number 06 under PS Bali district Howrah, measuring an area about 0.1850 acres out of total area 0.400 acres, was acquired along with the many other plots of land under the provision of the West Bengal Land Acquisition Act 1948 in LA case number LA of 86-87 for the public purpose of creation of better living conditions in rural and urban areas by construction of dwelling houses, as also for establishment of commercial and industrial estates. West Howrah area development project and purposes incidental thereto notification bearing number such and such dated 28th February 1990 issued under section 41A, but notification was issued under section 28 to 1990 issued under section 41A of the West Bengal Land Acquisition Act 1948 was published in the Calcutta Gazette on 6/3/1990. Possession of the land was taken by the state and was, my lord, kindly consider, possession of the land was taken
Yes.
before award. And made over to the answering respondent authority being KMDA on 24th May 1988. Possession of the land was taken before award.
Not absolutely unknown to law, can be done under certain circumstances.
My lord, kindly consider this
1894 Act.
may be public purpose for the construction of the dwelling houses, not for construction of road or hospital or such and such. Upon due completion of the acquisition proceeding, the land got vested in the state and the government of West Bengal by executing a deed of conveyance being number such and such for the year 2004. Absolutely transferred and conveyed the right title interest in the said acquired land, including the subject in favor of the answering respondent authority being KMDA for execution of its various development projects, and thereby the KMDA became the absolute and lawful owner of the said land of the exclusion of all others. My lord, photocopy has been annexed, my lord. My lord, your lordship kindly see.
What is your prayer? You're asking for restoration.
For restoration.
Not, you don't want the compensation.
Compensation money, if not possible, the restoration.
Because land once vested cannot be divested. That's the law. Award was wrongly paid to someone else instead of you. So you can claim the award.
My lord, I am my lord. My lord, it is admitted fact that the award has been passed in the year 2006.
Yes.
My lord, under the new law, Right to Fair Compensation and Transparency in Land Acquisition, Derivatives and Resettlement Act 2013, my lord.
Yes.
My lord, your lordship kindly see section 23. Section 24. Section
Yes.
24. Land acquisition process under Act 1 of 1894 shall be deemed to have lapsed in certain cases. Notwithstanding anything contained in this Act, in any case of land acquisition proceedings initiated under the Land Acquisition Act 1894,
10th April.
Where no award under Section 11 of the State Acquisition Act has been made, then all provisions of this Act relating to the determination of compensation shall apply. Or B, where an award under Section 11 has been made, then such proceedings shall continue under the provision of the said Land Acquisition Act as if the said land has not been repealed. But 2, notwithstanding anything contained in subsection 1 in case of land acquisition proceeding initiated under the Land Acquisition Act, where an award under the said Section 11 has been made 5 years or more prior to the commencement of this Act, where an award under the said Section 11 has been made 5 years or more prior to the commencement of this Act, but the physical possession of the land has not been taken or the compensation has not been paid, the said proceedings shall be deemed to have lapsed, and the appropriate proceeding government, if it so chooses, shall initiate the proceeding of such land acquisition affairs in accordance with the provision of this act. My lord, then, my lord,
24(2) is not applicable in your case.
my lord, is it applicable? Okay, why? My lord, I am submitting before lordship. Your lordship, my lord, your lordship kindly come at page 7 of the report filed by the respondent authority, KMDA.
Yes.
Certificate of possession of land.
Yes.
Certificate of land and over all its parties or whereas it has been acquired. Certified that I have this day, the 24th May 1988, received possession of the lands of Sunil Kumar Mukherjee. Sunil Kumar Mukherjee, not Simanto Chakraborty or Gopal Chakraborty, lead petitioner. Sushil, land situated in village Mauja, Khalia district, Hooghly, has been dated blank for the purpose of court, Howrah Township. Possession delivered. The land,
Possession was taken.
possession of the land was not taken from the lead petitioner or father or his father in the year 1988. Possession was taken from Sunil Kumar Mukherjee.
Sunil Kumar Mukherjee is the acquiring authority who has handed over to the requiring body. Possession will be taken not from the owner, from the acquiring body.
But 1988, award passed 2006. Under the new old act, my lord, award should be passed within 2 years from the date of publication of the notice.
Did your predecessor challenge that before the court?
I am not been. I have no notice was served upon me. I only came to know when the office of the from a person that my land has been acquired. Then I made a letter to different authorities. Since 2004, my lord, 2007, I have not given any chance to make objection.
Where is your letter in 2007?
My lord. Annexure P2, my lord.
Page?
Page 21 of the writ petition.
It was vested sometime in 1988.
As per report, 88, as per report filed by the KMDA.
The state has not come up with a report?
My lord, no.
No, we have not filed any report, but we have passed our reason order. From the reason order, everything is clear. The award has been declared in favor of the wrong person. It is admitted, my lord. It is a not.
When was it declared? Within the
This is Act 2, my lord.
Yes, Act 2. It was.
Firstly,
Why Act 2? This is 1894 Act.
No, madam. Land Acquisition Act.
Land Acquisition Act, not
Land
Act 2.
acquisition.
No, the proceeding has been initiated under Act 2. Land Acquisition proceedings.
Later on, it was switched to Act 2.
933AB. Yes. So it is Act 2, not Act 1. Now.
Act 2.
Yes.
And 2013 Act is applicable if otherwise not made inapplicable. When was it acquired and when was the award?
In my report, it is made clear. Paragraph 4 is clear. After section 3(1), my lord, possession was taken.
1990 was the 4(1)A notice.
Yes. And page 6 is the 4(1)A notice.
Yes.
Notification.
That is in 1990.
90. Since the proceeding could not be completed, my lord, within time, then the proceeding was switched to Act 1
by issuing 93B notice, the proceeding continued and award was declared. That is also reflected from the order.
Switch to the 89, the Amendment Act, that is not in your report.
That has not been specifically mentioned in the order impugned. Just a minute.
I think the state needs to file the acquisition documents.
Yes, yes.
When it was acquired, when possession
Because
given
that is-
acquired is
that
there.
that is everything they have disclosed in the order impugned.
The date of the award,
Date
when
of
was
the
the
award
9,
has been disclosed.
Section 9 notices?
Nothing has been. The date of the award. My lord, on 24th August 2004, the official records which was declared. Yes, 24th August 2004. Award was declared
Where are you reading, Mr. Talukdar?
at page 69 in the impugned order. Now the admitted
There is the date of award,
date of award is
24th.
August 2004.
Third paragraph.
Third,
I had gone through the
fourth
official
paragraph. Fourth paragraph. I had this paragraph starts with me, Lord. I had gone through the
I had got
official
to-
records.
Yes, yes. When was the section 9(3) notice issued?
That is also not material. This is not under challenge. Here the case made out by the
No,
petitioner.
no,
If
he
you-
is claiming restoration. If it cannot be restored, he has to be given compensation.
It-
Now, under which act? That's the question.
it is
So to deal
obviously
with
it
that,
is
To
it is
deal
ob-
with that, these issues are
this
necessary.
compensation. What is held in the order impugned also, this should go in favor of the correct person, because it appears that the person concerned was wrongly mentioned. It was in the name of Satish Mali, but it should have been Milord in the name of Srimanta Chakraborty. That's the mistake committed in passing the award. Whether that will itself vitiate the acquisition proceeding or not, whether
The acquisition
Resto-
proceeding has not been challenged at all.
not been challenged, and under the law, Milord, for that error or mistake, the proceeding cannot be vitiated.
No, no, 24(2) doesn't apply because possession was
Neither
taken.
24(2) applies, nor there is any provision in the either in the Act 1 or Act 2 that for such error or such mistake, inadvertent mistake, the proceeding itself would go and the land to be restored to the
Not go, the petitioner has to be compensated. Now the
only
question is, if it should be under the
No.
1894 Act or under the 2013 Act.
what he has pleaded on the last occasion also, that he didn't get any opportunity to raise objection.
Yes.
That he argued. I am repeating
Yes,
this
yes, yes,
argument.
yes, I am.
But you've not
Whether-
raised the acquisition proceeding.
My lord, my lord.
Yeah.
I
challenged
only,
the
no,
acquisition
no.
proceeding.
No.
So-
You have only asked for restoration of the land.
He has some
Restore the
questions,
land. Restore the land.
some
Land is total,
questions, Milord,
still
to
vacant,
be considered, Milord, here.
unutilized.
When, if you Lordship kindly come to some documents I will be showing to you, Lordship. Page 11, if you Lordship kindly see is paragraph 30 of the writ
Of the
petition.
report.
No, writ petition.
Yes.
Petition.
In paragraph 30, the petitioner says, the petitioner is the absolute owner of the land in question since October 2004, when he came to know that the government, without the knowledge, forcibly taken possession of the land in question, made in several representations. So the petitioner came to know about this possession. According to him, though possession was taken long back in 1988, But according to the petitioners, in 2004, it came to their knowledge. But when they have approached this Honorable Court in 2022, after several years, and my lord knows that by making repeated representation, my lord,
But my submission, my lord, no response was given to by the respondent authority to the petitioner. That is why.
no response was not given.
Not
that
given.
that cannot, my lord, have page 27 onwards, his representation, not 27, 21 onwards. But he did not approach the court of law for redressal of his
He approached
grievances.
the authority did not respond. So there is no delay.
That will
cannot
not,
make the delay
that itself, by making repeated representation, that will not extend the cause of action.
It will extend the cause of action, Mr. Talukdar.
Extend that.
He was not sitting tight over the matter. He had taken steps. The authority did not reply.
My lord, it is held by the Honorable Supreme Court that repeated representation will not do. One has to. If
Do
the
you have the
authority,
judgment with you?
yes, today I have not brought, but I can bring.
Doesn't say so.
I can, when so far I recollect, my lord, there is authority, my lord, to that extent. That repeated representation doesn't extend the cause of action. One has to come before the court of law within time.
I would like to differ with that. Please show me the judgment.
Yes, I'll
Because
show.
if the petitioner
That apart, that apart, what remedy the petitioner, it is an admitted fact that the award was not declared in favor of the real owner. Then what is the consequence, my lord? On the last occasion, I have submitted, my lord, at best, what is held by the collector also, that this amount which is lying with the collectorate, he will get that amount that will be disbursed in his favor. But what additional relief he can get, that amount along with higher interest, and nothing more than that. And on this score, my lord, whether he is seeking restoration is not possible.
And interest from the date of dispossession till payment.
Yes, interest is liable, because since he ought to have got that, which he did not. So he can be compensated in that way.
Are you agreeable to this?
No, my lord.
Only
No.
My submission before your lordship.
And if
land is still vacant.
If not be so, my lord, on the last occasion, lordship asked me to show the authorities, because his restoration, if my lord directs restoration, then the proceeding has to be held invalid. Whether there is either any challenge in the writ petition, or law permits him to get that.
Since the vesting has not been challenged in this writ petition,
My lord.
a vested land cannot be divested. That's the law. So the question of restoration goes.
Restoration goes.
You have admitted the vesting by not challenging it.
No, I am not, because no notice was served upon me. My lord, I made it.
Your predecessor has not challenged it, and you cannot.
My lord.
But at present, you're not in a position to
But
come to court with all the
my
details,
lord,
right?
Article 300A of the Constitution of India.
I have brought that.
My land, I have this is my constitutional
But you
right.
have not challenged the vesting. It is your land to be entitled to compensation.
My lord, I am praying relief under Article 300A, because my lord, the land, this is my constitutional right to have a land, to reside the land, to this that was the livelihood, because I have two sons. At that time they were unemployment. Now still they are unemployment. I was intending.
Have you challenged the vesting proceedings?
No.
Then how can you make these submissions? These submissions actually mean you are challenging the vesting.
My lord.
Kindly see the grounds formulated.
My lord.
Kindly see the grounds formulated in the writ petition.
Your only contention is that since they have not utilized, you want it back.
My lord.
But land, you are aware, the law says once vested cannot be divested.
Well, let that compensation be done under the new act.
My lord, I have brought certain decisions, my lord. If your lordship permits,
All that
if
compensation.
Yes. How to be made? My lord, one case has been decided by the division bench in a situation, my lord, where the Act 2 proceeding lapsed. It was not switched to even Act 1 by issuing 93A or 93B. Under such a situation, what the Honorable Court
Under
held,
such a situation, 2013 Act is not applicable at all. If 9 has not been
2013
issued,
Act is not applicable. The petitioner, how the petitioner cause was remedied. As the assessment was already made and the amount was lying with the collector, then the Honorable Court directed the amount to be paid along with interest at the rate of 9%.
you will be granted interest from the date of disposition. That is,
My lord, but I am submitting one judgment, my lord. Two judgments.
let Mr. Talukdar complete. Yes, paragraph.
My lord, without placing all these paragraphs, if your lordship kindly come to the order is not paginated. That's the problem. Second.
The last
No,
page is sufficient.
Fourth page from the last, if your lordship can.
Have you received a copy of this judgment?
No. I have only 2 copies.
It's an
I'll
undated
give him.
judgment. Please hand over a copy. Yes.
I'm reading that. I'll supply him a copy.
Yes.
My lord, may I read this relevant portion? As observed earlier, the failure on the part of the collector to serve notice in terms of the mandatory requirement of subsection 3B, which came into effect from 2nd May 1997 under section 9 of Act of 1894, after the Act of 1948 came to an end, has resulted in the proceeding having lapsed. At this stage, we take notice of the written instruction which were placed before the learned single judge by the learned counsel for the state respondents. The land in question was requisitioned measuring an area so and so by publishing notice under section 3 of the West Bengal Land Acquisition Act 1948, and notification 4A was published in the Calcutta Gazette on 2nd July 1973. Possession of the land was handed over to the requiring body on 29th April 1978 for construction of Ojoy Right X Jamindari Embankment Sagira to program. But payment could not be made for the said acquisition for want of fund. The executive engineer, Diamond Harbour Road Works Division, Durgapur 2, was requested for placement of fund amount rupees so and so, but due to non-placement of fund, no further action was taken from this end. Placement of fund, which is liability of the requiring body. It is clearly evident from the above instruction that possession of the land was handed over to the requiring body on 29th April 1978, but compensation could not be made for the said acquisition for want of fund. The question in the facts of the instant case is whether the deed petitioner liable to be paid compensation, but whether such compensation shall be paid in terms of the Act of 2013. If one looks carefully, one would notice that in the facts of the instant case, the land was requisitioned under LA case number so and so and was handed over to the requiring body on 29th April 1978 for construction of so and so. Notification under section 41A of the Act of 1948 was subsequently published in the Calcutta Gazette on 2nd July 1993. Although an amount of rupees 20,70,183 was sought from the requiring body, that is executive engineer Damodar so and so, but the authority simply failed to place the fund. Subsequently, after expiry of the Act 1948, the collector Bardwan simply abdicated his statutory duty to issue notice under section 93B of the Act of 1894. This could be either due to sheer carelessness or negligence on the part of the collector of Burdwan. Undoubtedly, it is only due to the collector's failure to issue notice under section 93B of the Act 1894, the land acquisition proceedings stood lapse. However, whether ipso facto such a lapse translates into a claim for compensation under the provision of the Act of 2013 can be answered simply by visiting section 24 of the Act of 2013. It will be noticed from a plain reading of the said section that there is a phrase proceeding initiated under the Land Acquisition Act 1894. In the facts of the instant case, it cannot be held by any stretch of imagination that the proceeding was ever initiated under the said Act of 1894. As such, abdication of statutory duty on the part of the collector of Burdwan to issue notice under section 93B of the Act 1894, either due to sheer carelessness or negligence on his or her part, cannot ipso facto translate into a claim for compensation under the Act of 2013. We do not know what prevented the writ petitioners from approaching the court at any time between initiation of LA case number so and so and the year 2014 for the purpose of seeking appropriate relief. Merely by making two representations, one in 2011 and other in 2014, they have sought for a issuance of a writ in the nature of mandamus for getting compensation under the Act of 2013 upon filing a writ petition only in the year 2014, by which time the said Act has already come into force. We find in the facts of the instant case the writ petitioners were slipping over their valuable right to get compensation for decades. As such, they simply cannot approach the court one fine morning when the Act of 2013 has come into force in order to seek compensation under the said Act 2013. Upon invoking section 24 of the said Act 2013, when the proceeding was never initiated under the said Act, under the Act of 1894. However, the respondents writ petitioners are certainly entitled to be paid compensation as applicable in their case. From the written instruction, which was taken notice of by the learned single judge, we find that a sum of rupees so and so was sought from the requiring body for payment of compensation to the writ petitioner. The said sum, together with interest at the rate of 8% per annum, to be calculated from the date of taking possession of the land in question, that is 29th April 1978, till, as admitted by the appellant in ground number so and so, till date of disbursement of payment shall be paid within a period of 8 weeks from the date to the respondent writ petitioner by the competent authority of the state. Here the factually 93B was not issued. Here the proceeding was switched and the compensation was also.
I do not find any averment in the order impugned also.
Yes.
That 93 notice was issued, 93B notice was issued.
That was, unless that was switched, award could not have been passed. That the collector ought to have mentioned that when 93B notice was issued, but that was not mentioned in the order impugned. But unless the proceeding was switched to Act 1, award could not have been passed. The award was passed.
2004.
2004. 24th August 2004, award was passed. So, my lord, I have placed this judgment to show the situation. Though here, my lord, some positive steps have been taken in this case. Only the mistake committed in recording the name of the owner, real owner. That itself, my lord, on the last occasion, my lord, I have placed one paragraph, my lord, from the Indore Development Authority's case.
You have only placed reliance. You have not.
I have not
wanted to.
I have not produced. Not only one paragraph.
Come back with the book today.
Yes. Only just 2 lines from the
Paragraph 141, I think.
142.
142.
142. And there in 142, another case has been cited that I have, perhaps I have handed over to your lordship. 142. There the case of Majors was referred to.
No, this is law. This is right law. Yes. Once vested cannot be divested.
No,
the development
42, mere irregularity.
Yes, yes. Even in that case, it cannot be held to be lapsed.
Is in my report also on affidavit, I have stated that it can at best be considered, my lord, as an irregularity, not illegality. And what I repeat, my lord, that in the act, either in Act 1 or Act 2, there is no such provision that for such error or mistakes, the proceeding will go. It is so. In absence of any such provision, the proceeding cannot be said to have been vitiated.
Yeah, the petitioner has not asked for
Not even asked for also.
It has not been challenged at all. It is
Challenge
not
that.
said the proceeding
So
should be held as
regarding the applicability, now the law stands as on day is 2013. Whether 2013 Act is applicable, it is not. As fell from your lordship also. That
No, I said 24(2) of the Act is not applicable because possession was given. Either possession or compensation.
Or compensation.
Either of the two. So since possession was taken, 24(2) doesn't apply.
Compensation
So it doesn't lapse.
assessed lying with the treasury, but could not be paid because of this mistake committed. So at best, and whether at this phase, আবার কি তুমি তো বলেছো তোমার পরেই তো ওরকম বলছি বলো তারপর রিপ্লাই দেবো তুমি রিপ্লাই দিও মিলর my learned friend will not stop here. He is not satisfied. Another judgment, only one paragraph I will be relying on. That is Shiv Kumar's case though on some other issues, but one issue has been dealt. Paragraph 18.
Yes.
Paragraph 18. The only paragraph, my lord, I will be relying on for this case. Even otherwise, the proviso to recognize a purchaser after Section 4. This is where an award has been made by compensation in respect of a majority of holdings paid. I'm relying this paragraph.
This is for subsequent purchasers. He has
he is not subsequent purchaser.
He has inherited the property.
No, I'm on other issues. The second, the compensation in respect of where award has been made and the compensation in respect of a majority of land holdings has not been deposited in the account of the beneficiaries, then all the beneficiaries specified in the notification shall be entitled to compensation under the provisions of 2013 Act. Here not the situation. It is not the petitioner's plot alone was acquired. A vast area was acquired which comprises several holdings. And it is not the case that in respect of the majority land holdings, the money was not deposited. They have been paid. Only petitioner
could not the disputes at all in the petition.
He is seeking compensation.
He is actually not even seeking compensation. He is seeking restoration.
From the bar. In the writ petition, he is prayed for restoration of the land.
We can deal with an alternative prayer of compensation. Yes.
Then it is held that the proviso makes it clear that in case of compensation, concerned authority majority holding has not been deposited, then the recorded owner at the time of issuance of so and so shall have the right. So it is not the case. My lord, two more, my lord, because he is pressing for the, hey, Dada, da.
Please serve the copies to.
No,
him
this
from
is
the-
reported. I shall, this is a reported. I'm giving the citation.
citations are
Oh, yes, citation টা দিইনি। এই শিবকুমারটা citation টা দেন।
সবগুলো citation দেখো, কোনগুলো সব বলে
ওইটা আমি তো তোমায় কপি দেবো, ওইটা তো আনরিপোর্টেড।
দিচ্ছি। Non-report বলো, reports।
2019 ভলিউম 10 SCC
2019,
10
10,
2019 ভলিউম 10
2019,
SCC
10,
229 এটা রিপোর্ট আর আনরিপোর্টেডটা আমি তোমায় কপি দিই। Well, this is reported in 2010 volume 4 SCC page 532
Paragraph.
paragraph 5 to 11. This is on the point, my lord, I have taken. I have shown from paragraph 30 of the writ petition that admittedly, although the possession was taken in 1988, the petitioner admits that, but it is averment has been made in the writ petition that in 2004 they came to know. Whereas in after 18 years, the petitioner is filing this writ petition. My lord, paragraph 5
This
to
writ petition, you submit,
huh?
not this writ petition. That was disposed of.
Earlier one
I
also.
am challenging the writ petition, challenging the impugned order.
My lord, paragraph 5 onwards. The issue involved in this petition is as to whether the acquisition proceeding can be challenged at a belated stage. The issue is no more res integra, as the issue has been considered by this court time and again. When a person challenges section 4 notification on any ground, it should be challenged within a reasonable period. And if the acquisition is challenged at a belated stage, the petition deserves to be dismissed only on this count. Here, case of Hari Singh versus State of UP referred to. A constitution bench of this court in Aflatun versus Lieutenant Governor of Delhi, while dealing with the issue observed in paragraph 11 quoted, to have set on the face and allowed the government to complete the acquisition proceeding on the basis that the notification under section 4 and the declaration under section 6 were valid, and then to attack the notification on grounds which were available to them at the time when the notification was published would be putting to a premium on dilatory tactics. The writ petitions are liable to be dismissed on the ground of latches and delay on the part of the petitioners. The same view has been reiterated by this court, observing that acquisition proceedings should be challenged before the same attain finality. In so and so cases, several cases are referred, my lord. Then, my lord, some other decisions were relied on. Then, my lord, may I skip to stateway, my lord, paragraph 11. There are certain cases were relied. In the instant case, it is not the case of the petitioner that they had not been aware of the acquisition proceeding, as the only ground taken in the writ petition has been that substance of the notification under section 4 and declaration under section 6 of the Act 1894 had been published in the newspaper, having no wide circulation. Even the submissions made by the petitioners accepted, it cannot be presumed they could not be aware of the acquisition proceeding for the reason that a very huge chunk of land belonging to a large number of tenure holders had been notified for the acquisition. Therefore, it should have been the talk of the town. Thus, it cannot be presumed that the petitioners would not have knowledge of the acquisition proceeding. My lord, I would like to emphasize on this: the petitioners bringing his knowledge in 2004, that cannot be, because in connection with the township, thousands of acres of land was acquired. So it was certainly the talk of the town, and the possession admittedly taken in 1988. Whereas after 17, 18 years, he is filing this writ petition. My lord, only one more decision I will be citing. My lord, this is reported in 2012, volume 12, SCC, page Chandrasekhar, 133.
2012?
12,
Oh, 12 batch.
volume 12,
Page number
SCC 133.
133.
My lord, paragraph. ছাড়ছে না কি করব?
Yes, paragraph.
Paragraph 25 to 31. That is already a field from your lordship. Paragraph 25.
Yes.
It is settled legal proposition that once the land is vested in the state, free from all encumbrances, it cannot be divested, and proceedings under the Act would not lapse, even if an award is not made within the statutory period, stipulated period. Then reference has been made to certain cases. 26. The said land once acquired cannot be restored to the tenure holders or persons interested, even if it is not used for the purpose for which it was so acquired, or for any purpose either. The proceedings cannot be withdrawn, abandoned under the provisions of Section 48 of the Act, or under Section 21 of the General Clauses Act. Once the possession of the land has been taken, the land vests in the state, free from all encumbrances. Then certain reference of the cases. The 27 is the most. The meaning of the word vesting has been considered by this court time and again. In Fruit and Vegetable Merchant Union versus Delhi Improvement Trust, this court held that the meaning of the word vesting varies as per the context of the statute under which the property vests. So far as the vesting under Section 16 and 17 of the Act is concerned, the court held as under. In the cases contemplated by Section 16 and 17, property acquired becomes the property of the government without condition or limitation, either as to the title or possession. The legislature has made it clear that vesting of the property is not for any limited purpose or limited duration. Then, my lord, in paragraph 28, 29, 30, certain cases are referred. My lord, straightway I am coming to paragraph 31. In view of the above, the law can be crystallized to mean that once the land is acquired and is based in the state, free from all encumbrances, it is not the concern of the landowner whether the land is being used for the purpose for which the land was acquired or for any other purpose. He becomes persona non grata. Once the land vests in the state, he has a right only to receive compensation for the same, unless the acquisition proceeding is itself challenged. The state neither has the requisite power to recover the land to the person, power to reconvey the land to the person interested, nor such person can claim right of restitution on any ground whatsoever, unless there is some statutory amendment to this effect. So this is the answer to the prayer made in the writ petition.
That's all?
That's all. In a situation, my lord, the division bench judgment which I have, that is the only recourse.
Directs me to direct to payment the under Act 31 and then you have to file my report. Which date the award has been passed, 9/3 has been sued, that is to be not disclosed.
That's why I wanted a short report from the state, because the order impugned is not very clear with regard to the dates.
Yes,
9/3B is not stated at all. It can be presumed that 9/3B was issued. Otherwise, it couldn't have been deposited.
Certainly, it was issued.
Award, but let us get the dates. And the
it was switched over.
Yes.
How could it?
Because it has to be 2 years from then.
Yes.
So that date is essential. Otherwise, it goes to the 2013 Act. The only issue has to be compensation in this matter.
Compensation.
Now, whether it is under the 18.
Regarding entitlement of compensation, we are not denying that.
It's not denied, not disputed.
The collector also is,
Whether it should be under the 1894 Act or the 2013.
and he is not disputing the award also. He is not disputing
I
the
am
award.
disputing the award. I am challenging the impugned order passed by the special land acquisition officer. Howrah.
But your challenge is only restoration, nothing else.
Restoration, but challenging that award. I
Also
I
not
cannot
claim
the ground,
compensation
the
under
only ground,
2013 Act.
the only ground petitioner was has taken that he was not notified. He was not aware of the.
Yes, absolutely. My lord,
So it is the eminent domain of the state. If the state wants to acquire, even if he raised, my lord, assuming he was aware, he could have raised his objection, but the state could acquire that land.
but no possession was
Then-
taken from the
so-
petitioner.
That's the opportunity he missed.
The difficulty is possession was taken from the predecessor. The writ petitioner has come into the picture much later.
Much later.
Well, if the possession was taken from the predecessor, my lord, let the document be so.
Possession was
whatever-
taken from your predecessor. So
Predecessor.
you cannot challenge that at this stage.
Well,
You have come into the picture much later. Though you are not a subsequent purchaser, you
no
have,
purchaser.
though I have said, though
I have
you are not,
inherited from my father.
I know. That's what I'm saying.
Huh.
You are not a subsequent purchaser, but then you have come into the picture much later. You do not know what your father has done.
My lord.
Whether your father has raised objection, whether that was considered, you are not aware of, you are not supposed to be aware of all that. Yes. So your only relief is compensation.
Well,
Now, and that
I-
is not your
I-
prayer at all in the writ petition.
That is not the prayer.
My writ petition, my lord, I am,
A certain amount
Yeah.
has been deposited as compensation before the authority.
my lord. My prayer, my lord, kindly consider, my lord. My prayer is to restore the land because no proceeding was initiated against me and no notice was issued to me. And I have been deprived from filing objection at the time of hearing. My lord, subsequently, my lord, I made a representation, several representations that no response was given to the writ petitioner. That is why writ petitioner came before this honorable court. And your lordship was pleased to direct the special land acquisition officer to pass an order, decision order after hearing the parties. My lord, pass a decision order, pass an order. That impugned order was challenged by the writ petition, by this writ petition. There is no delay. My lord, my learned phrase is raising question about delay.
No, even without that aspect, even we do not consider, even on merits, the order is in your favor.
My lord.
They have deposited compensation amount before the authority, you are entitled to take the amount.
My lord, not the award was passed in favor of the wrong person, not in favor of the writ petitioner.
It is an irregularity, it's not an
But
illegal.
that irregularity is on behalf of the authority, but landowner
That's
cannot
why
be
you-
suffered, my lord. I am
That's why you are entitled to interest.
no
That's
interest,
the reason, because, and that is not your prayer at all. Your
Your
prayer
offer-
is only restoration.
my lord.
If that is your prayer, it has to be dismissed. Writ petition will be dismissed.
It has to be.
It cannot be restored. You have no alternative prayer in your writ petition, sir. You must understand.
My lord,
All your prayers are for restoration.
my lord. My lord, this writ court has enough power to mold the prayer.
That's why I intend to mold it by granting you compensation
My lord, but
along
under
with
the new act.
interest from the date of disposition till payment.
Under the new act. Under the new act.
Please substantiate how you are entitled under the new act.
Under the new act, that is the
How are you
My lord,
entitled under the new act?
The proceeding was initiated under the new act.
Proceeding was not initiated under the new
No
act.
award is there is no award. Award is left. Award was left.
Award, sir, it cannot lapse because possession was taken.
The point was taken not from me
Your predecessor.
or predecessor.
Yes, so you are not a separate entity. You have stepped into the shoes of your
Well, it's-
predecessor.
My lord, your lordship kindly direct the authority to submit the document. The
What document?
possession was taken from the predecessor of the writ petitioner.
Possession certificate has been filed.
But taken, my lord, but not from the writ petitioner, not from his father.
Possession has to be taken from because it was your property.
But they
The
are not, my
possession
lord.
certificate shows the name of the acquiring body.
Acquiring body,
The
maybe.
acquiring body doesn't take possession from the petitioner.
Maybe, my lord. But kindly consider, my lord, for when the possession was
I'm
taken.
afraid, please take instructions and come back. You can at best claim compensation and interest on that. an amount has been deposited, the court can grant you interest from the date of disposition till disbursement.
My lord,
Disbursal of the amount.
once more, may I trouble your lordship with the two paragraphs? Two paragraphs of
In
that.
this case, there is no further relief can be granted.
My lord, paragraph,
Next statement,
paragraph
my lord, I shall
129,
reply, my reply, my lord.
paragraph 129 and 132, very small paragraphs. 129 and 132. This is the
129.
129 at the top left-hand side. One 129 has got 1.1.
1, 2, 3, 4 is there.
Yeah, one, not 1, 2, 3, 4. 129. Correct.
Yes.
1, 2.
Yes. This is 24/2.
And one more, yes, and then 132 and 132. The interest which we are offering.
9%
voluntary.
and 50%.
Yes.
Yes. That will not be a meager amount, sir.
My lord, I am submitting. No.
Best he can get that relief.
Section 30, please.
We're offering that.
Submit করতে দাও আমাকে, তুমি তো বলেই যাচ্ছ।
Second.
My lord, section 30.
Please show me that this act is applicable first.
Because section 23(4), section 24, of section 2.
For that reason, I wanted to see the section 9 notice. The
Section-
9(3)(b) notice.
Subsection. This act is applicable.
Subsection 2 is not applicable, sir. I, at the cost of reiteration, have to say this. Subsection 24(2) says, if possession is not taken and compensation not paid.
My lord.
If either possession is taken or compensation paid, 24(2) is not applicable. So in this case, possession was taken.
No, not taken, my lord. On my submission before your lordship, poison was not taken from the petitioner and not his father.
So who has given possession? How does the possession
he-
certificate come?
My lord, authority has power to take possession of land without consent of
Mr.
the.
Gotopal, please come back with the relevant documents. I have decided on it, but please, I need to
So
see
far,
the
I am
documents.
concerned, Miller. I am concluded my submission. I will not.
Entire submission is concluded. I would just like to see the
Only
documents.
my lord, judgment would be deferred. But
I was actually bent on passing the order here and now, but then please come back with the
well,
documents.
I shall submit, cite some judgment next day, my lord.
Very well, very well.
I
Will you
thought,
come back
Miller,
with a
the
short
decision-
report?
the
Yes,
report
Mr. Fine.
Please annex all the
documents,
acquisition, possession, and award documents. Right?
including that maybe.
All the documents relating to the acquisition.
he can come with. He can come with all this.
A report and annex. He has to annex these documents.
My lord.
Her learned counsels for the parties. Paragraph learned counsel for the state respondents seeks to submit a short report in the form of affidavit, annexing all the relevant documents with regard to acquisition of the plot in question. Paragraph, let the matter appear under the same heading on 23rd April.
We
23rd.
will not resubmit our.
Not necessary.
Yes.
Not necessary.
I
No,
shall
but the
give my reply.
submission is yes.
I shall give my reply, my lord. Well, he made submission, he made submission, I shall make on that day. I beg to appear on the petition. Well, this matter, my lord, I am challenging the 10-4 subsequent. My learned friend took time to produce the documents. Initially, a document was produced, call for the record, you produce the record, but your lordship was not satisfied. Thereafter, he took time to produce the record.
Yes, where is your report?
Yes, my lord.
No copy was served to me.
দিচ্ছি এখনই দিচ্ছি কেন দেবো?
Time লাগবে না।
Served in advance.
আমার না।
My lord. My lord, my report and document is supporting the case of the petitioner, my lord. The land has been acquired, my lord, 22 acres out of 32. That is my report, my lord.
In every case.
What is the petitioner's case?
Petitioner case is that, my lord. Petitioner case is also that. Out of 34 acres, 22 acres were acquired.
I have annexed, my lord, all the relevant documents relating to the acquisition, my lord. Award has been paid, my lord. Possession has been taken by the last annexure.
So you're in possession of the remaining 12 decibels. That's your right to land.
That's my case.
It is a report of the land acquisition officer, madam.
That is yes.
What is your prayer?
My prayer is, my lord, to set aside the impugned order, my lord, under 10.4.
Impugned order at page?
At page, my lord, that is, it starts from page 31, my lord. Operative portion is page 38.
This is the 10-4 order.
10.4 order.
And what does the report say?
My lord, report kindly come, my lord, paragraph, my lord, 2A. May I read, my lord? 2A, that
Yes.
after necessary verification and inquiries of the extremely old and available documents connected to the subject land acquisition, case number 06 of 1965-66 under the Defense of India Act, it reveals that in respect to the subject LR plot number 1495 being RS number so and so under Mauja Bindabanpur in jail number 11, Raninagar 2 block, total 0.22 acres of land out of 0.34 acres has been had been requisition and acquisition in connection to the said case for the purpose of construction of Akhirganj Katlamari Road in the district Murshidabad.
So you admit that the petitioner is occupying his Rayati land?
Yes, yes.
Yes, my lord, as per report of the LA officer, my lord.
Let it be disposed.
And documents also, my lord, say so. I cannot manufacture the document, my lord.
Report in the, yes, let it be disposed of, it will be set aside. You are appearing for, sir?
Respondent number 11, ma'am.
At whose instance it was initiated?
He filed a writ application.
Earlier, yes.
Consideration order, subsequently 10.3, subsequently 10.4.
A report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph.
My lord, he is not the officer,
Counsels.
not the state respondent, my lord. He is not a party of this petition, my lord.
On behalf of the state respondents.
My lord, my lord, my lord, my lord.
It is filed on your behalf.
My lord, pursuant to my lord's direction, he filed the report.
The petitioner has assailed the order passed by the district magistrate and collector, Murshidabad, under section 10 within bracket 4 of the West Bengal Highways Act 1964 on date of the order
31st January 20,
10/2/2023.
10th February 2023, my lord.
My lord, in this matter, my lord, RA case is there.
yes.
RA case, my lord. My lord, I file a, my lord, affidavit, my lord. Kindly see, my lord.
Are you differing with the submission of the state and the petitioner?
My lord, state submits them, my lord. It is, my lord, acquired by the Defense of India Act.
22 decibels, not the entire land.
22 decimal. My
So
lord,
the remaining 12 decibels, the petitioner.
my lord,
is
my case
supported.
is 32 decimal acquired.
The state says it is 22.
My lord, kindly see the
And you are the private
report
respondent.
filed the state. My lord, kindly see. My lord, my affidavit, my lord.
Report আপনার affidavit, হ্যাঁ. Exception about that.
Page, my lord, page 12 of my 11, my lord, respondent 11 filed my lord affidavit.
Yes, page.
Page 11, my lord.
Yes. Page 11.
That report filed, my lord, the court below, my lord. It is civil suit is pending. My lord, BLRO filed the report. Kindly see, my lord, page 11, my lord.
This is a plaint. Yes, a part of a plaint.
out of the plane, and my lord, that report filed by the
Filed by the
BLRO.
BLRO. Here a land
Where is
acquisition.
the BLRO's report? I do not find.
It is a my lord, first two reply was filed, two exception was filed. It is a first my lord dated my lord. It was affirmed on 9 January 9 June 2023. My lord, kindly my lord, this is my copy. My lord.
This is August.
What is it?
9th June, yes.
Page 11.
Kindly see my lord, page 11. Specific case, my lord, BLRO, the 32 decimal has been acquired. And in respect of suit is pending.
This was the challenge earlier, that it has been wrongly recorded
Yes.
as 2 decibels.
BLRO has no
And
option.
the record of rights is, I think you have applied for correction
Yes,
of record.
initially, my lord, this report, BLRO report, the state also initially says that 32 decimal. Subsequently, by scrutiny of record, it found 22 decimal. BLRO has no jurisdiction.
In that
LA has
suit is pending.
Suit is pending with regard to what? What is the
In the same malad in respect of self tax malad. Whether malad that is 32 or 22.
where is the suit, the plaint?
Page 5, my lord. This suit. देखिए हमारे replay টা বলো। কি করে দেবে? আমরা করেছি তো। সূত্র কারা করেছে?
When the state says there is no encroachment and the records support this said contention, you are being the private respondent, you have no role to play at all.
There's no authority.
The state has verified all the records and has come to the conclusion that
Yes, ma'am.
they are occupying their own land.
Here,
No, I am not occupied. I am not occupied. But malad, in my front malad, they malad constructed, made malad.
my
That is
land
my
I
case.
construct.
That
Here,
is
my
their
lord,
own land. Let it be disposed of.
ঠিক আছে আপনি আপনার সাবমিশন রেকর্ড করে দিবেন আপনার
একটা রিপোর্ট দাও malad a report can be malad supply to me malad.
Let me pass an order. Where is the date of the order impugned?
page 31, my lord. 31st January 2023.
Yes, but you said February just now.
No, my lord. 31st January, it was communicated to me on February.
31st January 2023.
সেটা আমিও
2023.
একটা কপি দিয়ে দিচ্ছি দাদা
Directing the
এটা কপি
subdivisional magistrate, Dome Call subdivision, Mushidabad to remove the illegal encroachment and unauthorized construction on PWD land and restored the same to its original condition. Paragraph. Learned counsel for the petitioner has submitted that out of 34 decimals of land in LR DAG number 1495, RS DAG number 1147, 22 decimals were acquired by the state and the remaining 12 decimals retained by the petitioner as her Rayati land. Stop. The record of rights erroneously recorded 2 decimals of land as Rayati land of the petitioner instead of 12 decimals. Stop. The petitioner has applied for correction of the record of rights, which is still pending. The petitioner is in occupation of the 12 decimals of land belonging to her and has not encroached upon any portion of the PWD land. The paragraph, the contention of the petitioners is conceded to by the state respondents, placing reliance on the report submitted by the Additional Land Acquisition Officer, Murshidabad, Learned Counsel for the state respondents submits that the petitioner is in occupation of her Rayati land comprising 12 decimals and the remaining 34 decimals have been acquired by the government. Paragraph, in view of the above, this court is inclined to hold that the petitioner cannot be said to be an encroacher / illegal occupier in respect of PWD land or any portion thereof. The order under section 10(4) of the 1964 Act passed against the petitioner declaring her to be an illegal encroacher is therefore required to be set aside. Paragraph, the writ petition is accordingly, the writ petition is allowed. Paragraph, the order impugned passed by the district magistrate of Kurota Payment. By the district magistrate and collector, Murshidabad, dated such and such is set aside. Paragraph, there shall however be no rise to costs since no affidavit registered by the sector.
Affidavit has been exchanged. Affidavit has been exchanged.
Reports, not reports.
Remaining 22 decimals. Your lordship uttered remaining 34, remaining 22 decimals was occurred.
Remaining 22 decimal?
Out of the entire 34.
Out of 34 to
22 decimal
22 decimals were acquired. Huh? 20, 12 and 22.
Get with the law.
Next. Yes.
Please, Lordship, Lord.
But the application.
Lord, I appear for the petition, Lord. Lord, this is an application for recalling of your Lordship's order.
Not the motion.
Lord, I just tell you, Lordship, give you, Lordship, a brief background of what happened.
This is an application.
Yes. Lord, what happens is, Lord, we withdrew.
Recalling of your Lordship's order.
Lord, we withdrew one writ petition. Your Lordship granted leave to file another one. The second writ petition was withdrawn, Lord, without any liberty. And the third writ petition was filed. A point was taken that since the earlier one was withdrawn without a liberty, the third one was not maintainable. Now, Lord, your Lordships, considering that, has dismissed the writ petition. This is an application for recalling of your Lordship's order. Lord,
What's your application? Can one?
Can one. There is an application for condonation that is 50 days delay, Lord. I'll place that as well. Lord,
What's that application?
that is can 2. Now, Lord, what happens after this is more important. Lord, we alleged that, Lord, the highway land has been acquired by Mr. Rai's client.
Going to merits, please justify your.
Yes, I'm coming to that. I'm coming to that. Just hear me for.
Merits.
Not on merits.
Technical issue.
Not on merits. Just hear me for 1 minute. What happens after the dismissal of the writ petition is, Lord, at the time of dismissal, Lord, it was at the complaint stage. 10(1) notices were issued after the dismissal. 10(2) proceeding initiated. 10(3) hearing done. Order of removal has been issued by the authorities. Now, as per the latest order, if my lord sees this, kindly have a look at this. Didi, eta din thakbe. Lord, kindly take the third page.
You are on merits of the writ petition.
No, I am not on the merits. I am telling you, Lord, so what has happened in this, then I'll go to the technical aspect.
What has happened? You
But-
have to justify your.
I will. I can, Lord. I am.
That first, I will not hear a line on merits.
My lord, I'm sorry.
I will not hear a single line on merits of the.
No, I'm not on merit. What
This
I'm
is
saying that
merits.
today, my lord, the order of removal has been passed and police date of, my lord, in removal of the encroachment of feast on 1st of March, but it is yet to be done. That's the situation. That's the today's situation.
Irrelevant. Irrelevant. in
Lord,
this case.
I
This is
would
already
say,
dismissed.
it would have some relevance. Let me come back to the application. Lord, kindly take the application. The prayer gulo dao, read to dao. Lord, kindly take, Lord, first page 14 of the CAN 1 application.
Yes.
Lord, this is the order by which your lordship, Lord, allowed us to withdraw the writ petition with liberty. So this is the, Lord, before this, I tell you, Lordship, in 2015, a writ petition was moved. Before my Lord Justice Sambuddha Chakraborty, as his lordship then was, then his lordship directed that you should direct the authority to take steps in terms of the complaint. That was not done. The things remain pending. A writ petition was filed, that was withdrawn. Now kindly take note, page 15.
Did you prefer any appeal against this order?
Your lordship's order. No, I'm
No.
for recalling. Lord, if I had preferred an appeal, then I could not have come. So, Lord, the third writ petition, 17370, page 15. The third writ petition
Yes.
was withdrawn without any liberty. Now, Lord, kindly take the prayers in 17370. I have got a copy for your lordship, Lord.
I repeat, I will not go into, please.
Lord, my submission is that the cause of action was different. So even if there was no leave, so Lord, the writ petition ought not to have been dismissed. To show that, I have to show you, Lordship, what are the prayer in the earlier writ petition. Kindly take that prayer, Lord.
So this amounts to sitting an appeal over the earlier order.
Lord, your
Cannot-
lordship has rejected the writ petition on the ground that since the leave was not sought to file the writ petition and the earlier writ petition was withdrawn,
Upon hearing you,
my Lord,
upon hearing your submission.
this point was not considered.
You cannot go back. Have you stated the point before this court?
Lord, this point
you
was
taken
not
the
considered. Lord,
before
if
this
the
court?
Lord, if that point was not considered or not taken, today I am before your lordship taking this point. That 2 points I am urging before your lordship. It is for your lordship to consider. One is that encroachment on a public land is a continuing wrong. For that, whether I seek leave or I don't seek leave, that is immaterial because the cause of action survives. Second, WP 17370 was filed with a prayer to Lord. I'm reading the prayers, Lord, for your lordship. The prayer was,
Have you annexed it?
Lord, it is not annexed. That's why I'm handing over a copy. Kindly have a look at it. Didi ekটু দেবেন? And this is the prayer of the writ petition which your lordship has dismissed. But if my lord has the file, my lord may compare the prayers. Absolutely on different prayers, the writ petitions were filed.
Give me a minute.
My lord, kindly. Lord, today the authorities also realize they passes an order of removal. And Mr. Rai's client doesn't have any right to retain the construction, which is on the public land. But kindly sees the prayers. Prayer in Lord, the present writ petition is mandamus commanding respondents to act and proceed in accordance with law, directing remove to demolish the unauthorized construction, PWD Highway Road as per the order dated 2nd March 2015, passed in WP 3437. This was a comprehensive writ petition. The earlier writ petition did not contain any pleading. That is why that was withdrawn.
The writ petition is not in this copy that you have handed over.
Lord, that is 17370.
Because there was an earlier writ petition also.
নাম্বারটা তো দিয়ে রাখবি Lord, may I check it? Lord, I 17370 তোমার কাছে আছে দেখো তো একটু Mr. Rai may have a copy দেখো তো
Do you have a copy?
Yes, 17370. Lord, I believe, kindly have a look at it. Lord, may I give this? Lord, this is with the number. Lord, kindly appreciates a person,
Identical prayers.
a person, Lord, the second writ petition.
Consideration of this representation is
Lord, the
also in
second writ petition was filed for implementation of the order of the first writ petition. The writ petition that is your lordship is,
are identical.
Lord,
I have kept both of them side.
yes, yes, I'm also reading it for your lordships. The prayer in 17370 was prayer A, Mandamus respondent concerned to consider and dispose of the representation made being annexed P3.
Which is prayer B of the second.
But I'm coming to that. For removal of the illegal construction, that was the mandamus. Here, the mandamus which was prayed was not for implementation of Justice Chakraborty's order. Not for implementation of one order passed by writ court. I can file another writ petition. This is the writ petition which was pending before your lordships.
You can file any number of writ petitions
My lord,
upon liberty being
Lord,
granted by the
Lord,
court.
your lordships have dismissed my writ
liberty.
petition on a
I am
technical
also
ground.
Have any
Lord, on a technical ground.
not
This is
technical,
a
sir.
comprehensive writ petition.
There are several
My lord,
decisions.
Lord,
that
this is
this
based
cannot
on
be done.
public policy. This is based on public.
Go before
Lord,
the
may I argue this before your lordships, my lord, without wasting your lordship's time?
We are only wasting time. This
Lord,
we cannot
hear
get-
my argument, then your lordship, my lord, decides the matter. Hear me, my lord, for
Your argument is on a wrong premise. You say they are not same prayers. I
Lord,
find
I'm
that
reading the prayers.
identical prayers.
I'm reading the prayers. It says,
Twist of language will not help.
Lord, I'm reading the prayers for your lordship again. The prayers in the present writ petition was authorities to act in accordance with law, direct, remove, or demolish the unauthorized and illegal structure made by private respondent on PWD road as per the order dated 2nd March 2015. So I said that you remove as per the order of the High Court. Earlier, my lord,
Next submission.
this is one. So according to me, the cause of action was different. Prayers were different. Second, an unauthorized construction on a public road with regard to which the private respondents have no right to retain the construction.
That is on merits.
Lord, that's a continuing cause of action. If I have not sought leave from your lordships to withdraw my earlier writ petition, the cause of action survives.
I'll further grant you leave to withdraw your application because I'll dismiss it. No ground at all. Will that inure to your benefit or will you withdraw and go before the division bench?
Well, Lord, today the authorities have passed an order of removal. Because of this order,
Not spend further time on this, sir. I'm sorry.
as your lordship pleases.
So I'll dismiss or you want to withdraw?
No, my lord passes the order.
I'll pass an order. Yes. The delay is being condoned. Step 2.
My lord, this will only inure to the benefit of the persons who is illegally occupying the land.
Taken liberty in that case?
Lord, again I submit this. Again I submit this, Lord, that for a continuing wrong, Lord, the law is that it applies to the public policy. Lord, it is.
That's why I suggested that if you can want to withdraw.
Lord, if I withdraw it today, then the situation will remain the same.
You have the honorable division bench with you.
Then, Lord, now I can also, Lord, if the client wants, they can also challenge both the orders before the division bench. Your lordship, today's order and the earlier order.
Of course they can.
That liberty is also there.
Yes.
That liberty is also there. That is for them to decide. But without instruction, I cannot withdraw. Then that will be against me also.
No,
Like-
that I can give you a day's time to take.
Like, Lord, the liberty was not sought by the lawyer, and for lawyer's fault, the client is suffering today.
Yes, okay.
You are
My lord may,
presenting
my lord may make one submission. May I make this submission to your lordships? My lord may make one observation in this, if my lord so pleases. Since the situation today is that the authorities want to remove.
Another issue.
Lord,
This is on
kindly,
merit.
kindly hear me for
Another
1
issue.
second what I'm saying. Lord, I will convince the client, we'll withdraw it. We may withdraw it. Lord, I'll come back with that instructions. That this will not prevent the authorities of what they are doing. Because they have already taken a steps.
I cannot do that. This
Lord,
court cannot pass
Lord,
that
these technicalities are a handmaid of justice. To do substantive justice, Lord, your lordship may do it. Your lordship
order.
is
Technical-
ample power under Article 226.
No, it's not
The
anything. under
public
this
property is being occupied. What is his right to occupy? No, zero right.
Who are you to say this? The
Let
authority
me
is to
pass
say
an
this.
order.
As well, sir.
Can 2 of 2023 করুন। The applicants / petitioners seek condonation of delay in filing the recalling application being Can 1 of 2023. Paragraph, heard learned counsels for the parties. Paragraph, good grounds being shown. The delay in filing the recalling application is condoned. Paragraph, can such and such is disposed of. Can one could. Heard learned counsels for the parties. The petitioners seek recalling of the order passed by this court on 11th July 2023 in WPA 7242 of 2023. On the ground that the cause of that the prayers
আরেকটা লিবার্টিও তো পাওয়া যায়
made
Lord,
in the earlier repetition being
Lord,
WPA
Lord, may I
17370 of
interrupt once?
2022.
Yeah. Lord, my Lord may grant me liberty to Lord that for implementation of the 10-3 order, if this not doesn't prevent me to come back with a writ petition or take steps in terms of for implementing the 10-3 order, then that will serve my purpose.
That be done? Please tell
My
me.
Lord,
Can that be done in
no,
a matter
that
which has been dismissed?
this 11th July order will not prevent me from filing further writ petition. That liberty will not serve the purpose because 10-3 they have taken a
If it
steps.
is a different cause of action, you can of course file a
But my lord may take stock of the situation and my lord, if my lord so pleases observe.
The sentence that you are saying tantamounts to recalling the order.
No, not recalling. That since I am submitting that this is done under 10-3, my lord may, if you will also so pleases, observe that this is the fresh cause of action, and if I want, if I am advised, I may take steps. Or this is the fresh cause of action. This one line will help.
This court cannot help you at all.
This 10-3 order is a fresh cause of action. If that 10-3 order.
Fresh cause of action, no liberty is granted. You try and file a fresh.
Because this 11th July order will now, they will say when I come back with a writ petition, that since earlier your lordship dismissed it, then I will not be allowed to file that.
I
Only
repeat,
that.
if it is a different cause of action, you can.
If my lord
law gives you the
observes that
liberty.
in this
You
order,
cannot
that
observe anything. I'll only dismiss your application, nothing else. Cannot be recalled. Should have been more careful. কি বললাম? That's the reason I suggested that you withdraw and you file, you go before the division bench if you want to. Since anyway, it's your choice. I cannot insist.
Lord, I cannot withdraw without an instructions, my lord.
হ্যাঁ, বলুন তো কি বলুন?
withdraw করতে পারবে?
Are different and distinct from the prayers in the present writ petition being WPA 7242 of 2023. Also, the cause of action in the earlier writ petition is a continuing cause of action, and the present writ petition could not have been dismissed merely for the reason that the earlier writ petition was withdrawn without seeking liberty to file a fresh writ petition on the same cause of action. Correct. On perusal of the prayers made in the earlier writ petition, it appears that the said prayers are almost identical to that of the present writ petition. The prayers may have been represented in a different manner, but they are identical. By the order passed on 11th July 2023, this court has made an elaborate observation with regard to the reasons for which the writ petition was dismissed on the maintainability issue. Stop. No subsequent ground has been made out by the applicants / petitioners for recalling / reviewing the said order. Paragraph. You read the CPC, Civil Procedure Code. ছোট বইটা আছে দেখুন এখানে এখানে দেখুন এখানে তার নিচে দেখুন Order 47, Rule 1 of the Code of Civil Procedure lays down the parameters which are required to be satisfied for review of a judgment. In terms of the said provision of law, an order can be reviewed on an application of a person aggrieved who, from the discovery of new and important matter or evidence, new and important matter or evidence which, after the exercise of due diligence, was not within his knowledge or could not be produced by him at the time when the order was made, or on account of some mistake or error apparent on the face of the record, or for any other sufficient reason. Stop. Paragraph in the case in hand, the petitioners have not been able to demonstrate any of the said grounds for review / recalling of the order in question. Paragraph, the application, being devoid of any merit, is liable to be dismissed. Paragraph, in view of the above, the application being can 1, right, is dismissed. There shall have been order as to costs as in certified website. Sorry, sir.
No, my lord, that it is your lordship has passed the order. I bow down to that. Lord, that 10-3 order your lordship has not taken note of, that I have handed over. That they have passed an order under 10-3.
No, I cannot. It is only whether this order can be recalled. That's
That is the subsequent document.
That is not a subsequent document. 10 proceeding was going on.
I have handed over the petition.
Next.
As your lordship.
Mention matters.
I have got.
Yes. Petitioner?
My lord, if the petitioner is the owner of the art.
Have you served?
Yes. Copy of it.
Union of India.
Union of India, NHI, you are appearing for?
I'm for Union of India, my lord.
Union of India. The NHI and the state.
Mr. Dey,
Mr. Dey is appearing?
For the state.
NHI?
no, that not I'm for Union of India, my lord.
Have you served the National Highways?
Have all the responsibilities.
Ms. Roy generally is there. She's not there today. Ms. Monica Roy is not there today.
It's appearing on courtroom number 6.
I would request her to appear in this matter. Please ask her to come if she can. Oh, please request her to come if she can.
Yes,
Yes,
Lordship.
yes, what is the matter? of-
What other petitioner, erstwhile vendor of the petitioner was 0.59 decimal was the owner of the land in Mauja, Unnasi, PS Jagacha, District Howrah. Thereafter, my lord, national height 59 and mark it 59 decimals, my lord. My lord, kindly mark it, my lord. Then thereafter go to the page 47, my lord.
Petitioner is the owner.
Yes,
Page 47.
yes, my lord. My erstwhile vendor is the Abdul Mannan, is the middle name, my lord. Kindly see, my lord, page 47 and SIP4.
Yes.
He was the owner in respect of 59 decimal of land, my lord. Government acquired, my lord, middle portion, my lord, kindly see Abdul Mannan. 3 names are there, my lord, 47, page number 47. Middle
Yes.
name Abdul Mannan.
Yes.
My erstwhile vendor is Abdul Mannan. Government by 2 acquisition notification, my lord, kindly top of this, my lord, particular.
You have purchased or you have inherited?
Not, a particular erstwhile vendor was inherited. Subsequently, my client purchased
Your
from.
client purchased.
Yes. And acquired, my lord, they give first notification 22.88 decimals and second notification 4.62 decimals equal to 27.50 decimals. My lord, out of 27.5 decimals was acquired out of 59. Balance land 31.50. My client purchased by deed number. I'll kindly see the deed annexer deed of conveyance, my lord, page 48, my lord.
Yes.
Thereafter, my lord, 64 subsequently mutated before the BLO concern and paid the rent receipt, page number 69, and also mutated before the Kolkata Howrah Municipal Corporation. Start from page 60, page 70 to 75, my lord. Thereafter, my lord, kindly see the annexer P8, page 79, my lord.
P8.
P8, page 79.
Yes.
My lord, National Ministry of Road and Transport, Government of India, National Highway Authority issued a letter treated as my client as unauthorized occupant. My client is the co-owner of this particular land, my lord.
Did you submit the representation within the?
Yes, my lord.
within
Kindly
3
see
days?
first representation, my lord. Page 76, only demarcation, my lord. Nothing.
Page 70. No, no,
76,
after
first
this.
by my client.
This is no, representation as stated in the notice.
Yes, my lord. Next, my lord.
The
Kindly
notice
see
is on 15 June 2023.
80, my lord. Kindly page 80, my lord.
Page?
80, 80.
So, yes, you can submit a representation, isn't it?
Thereafter, nothing was taken. Not to take any steps.
This has not been disposed of.
Only, my lord, finally demarcate particular the acquired land and unacquired land.
This is a demand of justice. This is not a representation. Why will the authority consider? You are supposed to submit a representation before the authority.
Kindly see all the authorities, my lord, kindly see the notice.
This is a demand of justice.
Demand
This is
of
not
justice.
called a representation.
No, ma'am.
You have to file a representation.
Yes, ma'am. While you treat this petition as a representation and dispose of within time, my lord.
Yes, she's coming. She's coming. I have informed her. Mr. De.
Yes, ma'am.
That is page 89, last paragraph.
Yes, ma'am. Even the petition.
No, what is the prayer?
Yeah, we will, last paragraph.
Prayer of the repetition, my lord.
It is requested that you physically demarcate my client's land. As also the balance land of our square.
Yes, obviously, my lord.
There will be normal.
One part
If you can show.
acquired by the state authority, another balance part is my client.
The acquired part can be demarcated, not your
Yes,
private
acquired
land.
part. Only direct
Your
only
private
acquired
land.
part.
Yes.
Yes.
Not for the acquired part. He paid for my lord.
No, my lord. Prayer of the writ petition, my lord.
Prayer of the writ petition.
Prayer of the
Prayer
writ petition, kindly see, my lord.
Page 28, first prayer.
Yes, my lord.
Let it be given as an order to pass the appointment pass the special officer divided to appoint the area surveyor from the panel of the order to give the response entire land and that give the subject under the ballot pass. Clear. One, to undertake an inquiry and demarcate through the respondent number 6 of the entire land.
And you have
the
not-
fact number or more practical stated hearing the subject matter of
Yes, my lord. Subject matter of the acquired, my lord.
demarcate the land.
You have
Acquisition.
annexed the notice, but you have not challenged the
Demarcate
notice.
the land which has not been acquired by the state. My lord, next paragraph. Next prayer. Roman 12. To demarcate the land which has not been acquired by the state.
That cannot be done. That cannot.
No.
So, my lord, for us.
Only demarcated, my lord. Acquired land, only demarcated.
And you have not challenged the notice.
No, my lord. Notice is the previous notice, my lord, is not challenge.
So you don't want to challenge the notice.
Yes, ma'am, I want to challenge.
Yes.
My kindly liberty to file supplementary affidavit.
How supplementary will not help you, sir. You have annexed the notice, but you have not challenged it.
No.
You should have actually checked it. Withdraw, file a fresh writ petition. I'll grant you liberty. You have to actually challenge the notice, nothing else. A 26-2 notice is hanging on your shoulders. Isn't it?
Alternatively, my lord, kindly direct to demarcate the acquisition portion. These are solve all these
So,
problems, my lord.
You don't
Only
mind if you're evicted in the meantime.
in the-
26-2 notice, you'll be thrown out.
20, my lord, received on September, October, my lord. Yes, yes.
And we are in 2024 now.
My lord, thereafter, my lord, file the writ petition, my lord. Kindly.
Which writ
Please.
petition?
This writ petition, my lord.
And you have not-
Notice received on, my lord, kindly see the notice received on
The writ petition is after the notice?
after the notice, my lord.
Because you have annexed the notice to the writ petition,
Yes, my lord.
but you have not challenged the notice.
No, my lord.
So let them proceed according to 26-2. Yes?
Yes, my lord.
Let them proceed with under 26-2, no difficulty. What
No
are you
difficulty.
saying,
Only,
sir?
my lord, so far as the demarcation is concerned, only no difficulties, my lord. Only demarcate and segregate the acquired land. All the
He is
problems.
not challenging. I'll request you to appear. I'll regularize your appointment. Since National Highways is served.
My lord.
There is a 26-2 notice. Please give her a copy of the writ petition.
Notice.
Mr. De, 26-2 is not challenged. I am surprised. And Ms. Roy is naturally happy. That is not challenged.
I'm not happy, my lord.
So he is asking for demarcation of the acquired portion of land. Let only that be.
That is, this prayer is not valid. It will not be-
First prayer.
Where is there, my lord?
First prayer.
Where is there?
Yes, my lord. It will not be-
The prayer.
Prayer I.
There are to undertake an inquiry and demarcate through the respondent number 6 of the entire land. And that number more particularly stated there in the subject matter of the acquisition under 2 notices. Obviously, my lord, without entire land, totally my lord, big prayer. We can't, my lord, if there is law, my lord, we must proceed that. I never, my lord, object in any consideration.
What are these two notices?
My lord, is not in proper.
No, no, even if we mold the prayer, then what are these two notices? What are these two notices? Subject matter of acquisition under the two notices. What are these notices?
Yes, my lord, kindly see page annexer P4,
Page
47. Acquisition notice, my lord, kindly see. LA case number. To acquisition notice. Case number, my lord. First 7576. Second 7879. LA case number.
Mr. De, why can't the acquired portion be demarcated? It's a very innocuous prayer. He's not asking for anything else. He has surprisingly not challenged the notice also.
This is because my lord, I am not the
This is your document, page 47.
Yes, my lord, I have seen that. But his prayer is not there.
The last part of his prayer.
His last part of the
More particularly,
first, my lord, according to him, my lord, you have to take care that.
we will mold
And-
the prayers, Mr. De. You are being very technical
Yes, ma'am.
today. I don't know. why.
And because, my lord, I never, my lord, object in him.
Let us, I will mold the prayer.
My lord, your lordship can mold the prayer. But according to these pray that.
No, no. Only the
And the
demarcation will be allowed.
My lord, may I, in the subject matter of the acquisition. My lord, may I ask himself, my lord, without measurement? What is the meaning of entire? My lord, without measurement of the entire land.
I will allow only the subject matter of acquisition.
What is the meaning of it? My lord, your lordship will, I want to read that. What is the meaning of it?
Yes, I've seen it.
It is the only dispute between the National Highway Authority and me. National Highway is not the, my lord, they will give us. Already hand over to the National Highway Authority, my lord.
Demarcation has to be done by the state, not the national highways.
My lord.
My lord, to undertake an inquiry and demarcate through the respondent number 6 yes, of the entire land and
Without-
the number more particularly stated there in the subject matter of the
Without-
application under the notice.
Without measurement, the entire
Only
59
allow the
decimal of land.
particularly that part,
Yes,
the acquired portion, nothing else.
My lord, he can't be, his prayer is not in that fashion.
The division bench will help you, Mr. De, after that.
My lord, may I leave, my lord, subject to lordship? May I leave, my lord?
I am appointing.
My lord, my junior is there.
Yes,
My
let
lord,
me do
say,
that.
my lord, I must file any in opposition of that.
Not necessary.
My lord, I say, your lordship will see this.
You can advest, you can advest, Mr. De, please do not delay the matter
No, my
unnecessarily.
lord, I say, my lord, in this matter to file anything in opposition. And because we are not,
Within 2 days, I'll allow your prayer,
No,
within
my
2 days.
not possible for me.
Then I will not allow your prayer.
Then, my lord, it was, disallow my prayer, but I pray this. And
I will ask for a report, let him come back with a report.
Yes, my lord, kindly read.
Since Mr. De is bent on not allowing me to dispose of this matter, let him come back with a report.
Sorry, direct.
Affidavit of service, none appears for the National Highways Authority of India despite service. Ms. Roy, who is present in court and usually appears regular as coronal appointment. Who regularizes your appointment? National Highways Authority.
National Highway Authority appoint for.
I have to inform the my lord, Ministry of Law, my lord. I have to take information.
National Highways.
Because everything, this is the different body, my lord. That reason.
একটু জেনে নেবেন কে রেগুলারাইজ করবে হ্যাঁ একটু মিস রয়কে ফোন করে জিজ্ঞেস করে জেনে নেবেন তারপরে the innocuous prayer of the it is contended on behalf of the petitioners that out of 59 decimals of land in the plot in question, comma, 27.50 decimals have been acquired by the state. Stop. the petitioners have purchased the remaining portion of the land
30.50, 31.50.
amounting to 30
Remaining portion 31.50 decimal.
remaining portion of the land করে দেখুন। From the remaining portion of the land from the erstwhile owner. Stop. A notice under section 26 within bracket 2 of the Control of National Highways within bracket Land and Traffic bracket closed Act, 2002 was issued upon the petitioners on 15th June 2023. Stop. The innocuous prayer of 23 declaring the declaring the petitioners to be declaring the petitioners to be unauthorized occupants of the plot in question. Stop. The innocuous prayer of the petitioners is for demarcation of the acquired portion of the plot. Paragraph. Upon consideration of the submission made on behalf of the parties, comma, this court is inclined to hold that since it appears from the reply issued by the Special Land Acquisition Officer within brackets HIT bracket closed, comma, Howrah on 18th May 2011 to the application made by the petitioner and petitioners under the Right to Information Act, comma, 2005 are made on behalf of the petitioners. Application made on behalf of the petitioners that 27.50 decimals of land out of the entire 59 decimals have been acquired by the state, comma, it is incumbent upon the state respondents to demarcate the said acquired portion of the land in order to identify the said portion and also enable the petitioners to utilize the remaining portion of the land. Paragraph. In view of the above, comma, the petition is disposed of. Directing the, who should demarcate, Mr. Dev?
I'll kindly direct the respondent number 6 with the help of the special, with the help of the, my lord.
6 is the director of land records.
Yes, my lord, only
He
main.
will not demarcate.
My lord, my practical, my lord, my respondent number 5, my lord, and 4 and 5, my lord.
BLLRO is not, yes, 10.
Yes, BLLRO is a party.
10. Directing the 10th respondent to demarcate the acquired portion of the plot in question upon service of notice to all concerned, including the yes. They issue notice by the for demarcation. No, I've said all concerned.
All concerned.
All concerned, including the petitioners and the National Highways Authority of India. Let me mention India. Within 2 months. Yes. Within 2 months from the date of communication of this order, representation is not necessary to be considered. He is not challenging that at all. Only the order. Oh, yes, only the order. Yes. The 4th respondent is directed to render all necessary assistance to such demarcation procedure and the
that is hard respondent.
No, assistance you said 4th respondent.
Without.
Not necessary.
K and I
Oh.
My
কেটে দিন ওটা। The
my
concern,
submission is the respondent number 5 is the main authority. This is special land acquisition officer. Main authority.
no.
With the help of the BLRO.
The BLLR will take the assistance of, he'll take the assistance of 3.
Yes, my lord. That because my lord, here is 26.
The third respondent করুন is directed to render all 5 and 3.
Yes, my lord.
Respondent numbers 3 and 5 are directed to render all necessary assistance, যেটা বললাম। No, the 3 and 5 করুন। All the parties are directed to cooperate with the authority. Stop. All the parties are directed to cooperate with the authority in the process of demarcation. Disposed of with that. Next.
My lord, I am appearing for the petitioner. Affidavit of service be kept on record.
Let it be called. Let it be called. Yes. Have you served?
Yes, my lord.
What about the private respondents?
My lord, respondent number 678. 5678.
Served, all of them?
Yes, my lord.
Yes,
My
what
lord,
is the matter?
only my lord, kindly come to page number 29, my lord. Your lordship was pleased to direct on 7th November 2022 to direct the petitioner to present a representation before the respondent authority, and also direct the respondent authority to consider the same and dispose of within 3 months from the date. But my lord, respondent authorities does not take any steps. We have made the representation, my lord. Kindly come to page number 31, the representation. But till date, respondent authority does not take any steps in this regard.
Let this be disposed of yesterday. The order has not been complied with, earlier order.
Yes, your lordship.
Affidavit of service. None appears for the private respondents despite service. Paragraph, learned counsel for the petitioners submits that by an order passed on 7th November 2022 in WPA 4887 of 2020, this court granted liberty to the petitioners to submit a comprehensive representation before the concerned authority and directed the authority to consider and dispose of the same within a stipulated time frame. Stop. The petitioner's apostrophe grievance therein was encroachment of PWD land adjoining their property by the private respondents by raising unauthorized construction therein. Stop. Learned counsel submits that the said order has not been complied with as yet, for which the petitioners have submitted a further representation before the concerned authority on what is the date of your representation?
My lord, 15th November 2022.
Where do I find the date? Where is the date?
My lord, it is not written in the representation, but
then how do you say the date?
My lord, there is a typographical error. It has not been mentioned.
Which has also not been date dite hobe na, which has also not been considered. Bracket annexure P5 to the writ petition. bracket close, which has also not been considered till date. The petitioners pray for a direction upon the authority to comply with the earlier order of this court and consider the representation submitted by them. Paragraph. Upon learned counsel for the state respondents submits that the fourth respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of directing the fourth respondent to consider and dispose of the representation submitted by the petitioners within bracket annexure P5 of the writ petition, bracket closed, and also comply with the order of this court dated 7th November 2022 in WPA number 4887 of 2020, within 2 months. Sufficient time has been given, 2022. Within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, in accordance with law. Disposed of for chapter.
Grateful, Your Honor.
Next.
Lord, this is the prayer for compensation, my lord. For a moment, your lord, is page 22.
Who is appearing for the state?
Page 22, lord, is
Here for the state.
page 22, lord, is passed an order. On that basis, my lord, physical verification is done. My lord, the utilization verification report, it appears land has been utilized. Thereafter, my client made the representation. My lord, the similar order has been passed in Annexure P4 by Justice Banerjee. Similar order. And lordship's also order passed in a similar matter. Also, kindly see. Similar order has been passed. Earlier. Refer to the land purchase committee, one of the.
There was a direction for joint inspection. That has been done.
Done. That is, my lord. After that, my lord, the page 28, 29. This is the joint verification report. After that, made the representation. That has not been considered. And lord, see the similar circumstances. Justice Banerjee also passed an P4.
Page 32.
Page 30. Page 32. 28.
No, your representation?
Page representation, page 32. Page 32. And the annexure P4 is, my lord, page 35. The similar order has been passed by Justice Banerjee, and lordship's also order passed in similar order. Same thing in the same modes. That's the order. I am addressing the annexure P4, the order passed against that division bench, going to the division bench, the division is failed. Thereafter, the contempt, in contempt already payment has been done. And the lordship also passed an order.
The plot is not acquired.
Yes, my lord. Not
Acquisition
acquired.
requisition proceeding has not been done.
Yes, that was utilized and that was confirmed by the special land acquisition officers. And he's telling that and the advice was given to the executive engineer Kakdeep from the spreadsheet before the direct purchase, my lord. The District Land and Land Development Commission.
And similar order lordship passed.
Have you seen this order, the earlier order?
Lordship.
So let a similar order be passed. Let there be a valuation of the property, an assessment, and then let them pay. Where is the letter saying that it was not acquired?
No, that is, my lord, that is all through,
Special Land Acquisition Officer,
that is all through, my lord, their land has not been acquired,
that is admitted.
admitted position. And that's for the particular purpose, joint verification was done.
So let there be an order to that effect.
Lordship.
Affidavit of service. It is not in dispute that the land of the petitioners was utilized by the respondents, though the same was not acquired
By the irrigation department.
by the irrigation
Department.
by the Irrigation and Waterways Division, though the land was not acquired, far less any compensation paid. Stop. Pursuant to an order passed by this court
And accept page 22.
on 16th February 2023 in WPA 2374 of 2018, a joint field inspection was held
Thereafter, I made the representation on.
This was held by the BLLRO.
BLR also present. Without BLR, with the
by the authority.
irrigation department, along with the acquisition department, joint verification done with the help of
And upon receipt of the inspection report, a verification report, the petitioners submitted a representation before the concerned authority seeking compensation at the present market rate.
Representation was made on 22nd September 2023.
Page 32 is the representation.
Page 33, the date. Date of representation.
Representation যেখানে বললাম না ওখানে
22nd September.
On
In the middle portion, 22nd September.
22nd September 2023. Where is the proposal of the authority for direct purchase? Is there any proposal?
That is, some matter has been a proposal, but a lordship's direction was also there.
No, this was on the proposal of the
A
authority.
proposal that has been done earlier occasion also lordships.
Yes.
These matters, there is no
So
such
do you
instruction.
propose to directly purchase?
No, there is no instruction from these regards. I am not getting any instruction.
So far, the not only one matter, lot of matters is there. Some matters already proposal is there.
But these matters I have not gotten
Matter,
instruction.
in the matter that you have given to me, this here a proposal was there.
Proposal in respect of the Mujain question that has been done. Some portion, my lord, the Muja affected many persons.
I am candid before your lordship without any instruction. I have not had these points. If there is a specific
And
proposal
was
was sent to this
direction
department.
is there. And lordship annexer P4 kindly appreciate to that. I have annexed in document. Annexer P4. Justice Banerjee also the propositive.
No, these are all on the basis of proposals given by the government.
Oh, this is, my lord, that is a submission made by the respondent authorities. Chandidev also appeared in the national P4, kindly appreciate to that. This also, the submission was made by them. Otherwise, there is no other way. In general proposition, in the other matters.
There are two ways. One is acquisition under the 2013 Act, and the other is
If it
direct
is the land is
purchase.
acquired.
If it is not acquired, they can acquire under the 2013 Act and pay a compensation accordingly, or they can directly purchase.
Right.
So he needs instructions on this. I cannot give a direction like that. There are two ways out.
That is to, my lord, the earlier occasions, lordships passed an order, similar circumstances, submission was made
This
by
is
the
not
respondent.
similar circumstance, sir.
I
Here there is a proposal from the authority to directly purchase. Learned Counsel has no instructions to that effect.
I cannot show before lordship since the respondent authority already appeared.
And in the earlier order, which is annexed, here also it is not said direct purchase.
No, lordships passed an order. execute the deed of transfer in favor of the respondents.
That application will be considered. That will serve his purpose, man.
That is a
File an application.
Page 32. Page 32.
Yes, ma'am, 32. That will be considered, my lord. Everything is there. His prayer is, my lord, last 33. মহাশয় সকাশে অধীনে অভিধান মহামান্য আদেশকে মান্যতে অধিকৃত জমির উন্নয়নের বিধি ও বিধান অনুযায়ী দেশের নিগত অধিগ্রহণে অধিকৃত
Yes, so let this be considered in that case because there is no proposal in this case.
I have objection to that. I cannot say, my lord,
Since there is no specific proposal, this will serve your purpose.
so all are theme or all are things, my lord, for the purpose of payment of compensation.
Yes,
Whatever
yes.
steps taken. This is
So
a
let your this be disposed of and compensation paid to you.
Lordship.
Salam alaikum, last line, sir.
No, no, direct purchase তো আপনারা
Wait, comma, which is yet to be considered. Stop the petitioners pay for a direction of the authority to consider the representation at the earliest. Who will consider?
executive engineer respondent 6.
Respondent number six.
Learned counsel for the state respondents submits that the sixth respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the petition is disposed of directing the sixth respondent to consider and dispose of the representation submitted by the petitioners within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, comma, in accordance with law, and take necessary steps for payment of compensation to the petitioners within 2 months thereafter. Within 2 months thereafter. Disposed of? Which are 2 months and 2 months for compensation.
One invoice, my lord, 720 and 721 the same thing. 720 and 721. If your lordship,
Let me call. Please wait.
if it is not called, my lord, then I have to make the prayer for adjournment. As because I have
No, I'll call. Let me see 18 and 19. Let me see just 2 matters at the end.
I'm waiting.
My lord, I'm for the petitioner, but my lord, this is a very urgent application, but lordship will recollect yesterday Mr. Manjit Singh appearing for the private respondent.
He
He
is
was
appearing
asking
this
for
matter.
time. It will not be right on my part to oppose. So my lord, let the matter be, let it be a time fixed matter because it's urgent. On
This will not be possible. It
My
will
lord-
appear under the same heading. That will help you.
my lord, on 3rd.
It will be
Because Mr. Singh, his junior is there, probably he will not
in
be
the month
available
of
even next week.
April any day.
and on prayer of the private respondent, the matter is adjourned. Private respondents. Paragraph, let the matter appear under the same heading on 5th April.
Deeply.
Next,
Well, it will retain its position in the list.
mention matters, same heading. English of same heading.
This is my application, my lord.
Same heading, same heading.
My lord, my land along with the structure has been acquired by them and a price has been fixed. I gave an objection to it. And then also I said, kindly, if you are not satisfied with my objection, send it to the arbitration. Because whenever they are acquiring any land,
Under the National Highways Act.
lordship. Now, lordship, whenever there is a acquisition, lordship, or a compensation, then the 2013 Act has to be applied.
Where required.
Right.
Not in all
Now,
cases.
yes. Now, lordship, neither that act they apply. They are taking my property along with the structure.
Have you filed an application? under
Lordship,
PG
now
filing?
lordship, yes, lordship. Lordship, kindly turn to page 36.
Primarily, you're unhappy with the compensation.
Yes. And lordship, I'm a,
Goes to 3G5.
because yes. My 3G5 request is at page 36.
However, both are satisfied. Can I say confirm?
This is a 3G5 application.
Lordship,
They is appearing in this matter. This has not been considered.
Yes, my lord, that will be considered. He is
Who
right.
is the authority?
Who is the authority arbitrator? 3G5.
My lord,
They filed the application before the arbitrator, learned advocate. The
Respondent
judge
number
is cited
6.
and collected.
Respondent number 6.
Well,
Yes,
my lord, the respondent number 6.
let the arbitrator consider within a stipulated time frame. Being unhappy with the compensation granted to him by the him for acquisition of his land under the National Highways Act, 1956, the petitioner filed an application under section 3G within bracket 5 of the National Highways Act 1956, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the application at the earliest. Shuruta affidavit of service.
I'm much obliged.
Paragraph. Learned counsels for the respondents submit that the Dujana. Sixth respondent be directed to consider the application in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the sixth respondent to consider and dispose of the application submitted by the petitioner dated 27th November 2019. Still
Can you
pending.
give me liberty that I will also file an additional to this because that's the client's
So will
drafting.
you
So,
file a comprehensive application?
Lordship,
That
I will
means
file a comprehensive application.
let this not be considered, file
Lordship.
comprehensive.
No, this will be considered as a notice and then
Very good,
comprehensive.
very good.
Lordship.
কি বলো? Dated such and such 27th November 2019. Within 2 months,
My lord.
2 months,
no, my lord, because election is my lord, the election officer.
3 months.
3 months.
Within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law, the paragraph, the petitioner shall be at liberty to file a supplementary application before the authority in this regard, if required. The law says that copy has to be given to you, so I'm not recording that separately. Copy of the award under the law has to be served upon him, disposed of, exactly.
I'm obliged.
Grateful to Allah. Yes, let me all the next 2 matters.
Dakun.
720.
Same as 17, my lord. I have the report.
What does your report say?
Report says, my lord, it's report of our special land acquisition collector. Land were not acquired, but it was utilized by the irrigation and water department.
That's
partly utilized.
Oh,
So,
that-
my lord, he is asking for consideration that page 40 is
That be done?
that be done by 3 months.
So it will be the same order as
Same order.
the earlier one.
My lord, 3 months.
17.
7.
Item 17.
2 months.
Representation at page 40.
Page 40 and the same date. But
Representation same date.
17, 2017,
Representation হচ্ছে
717 যেটা পরেটা 21
22nd September 2023. তাই আছে বোধহয়। Huh? Same date. Same order.
the next matter is also same.
I'm appearing with the state.
Who is appearing? You have heard the earlier 2 matters.
Same.
Any instruction?
No, same.
No, it has an instruction
Same
submitted on
instruction,
behalf of
but it
the
has
state respondent.
has not been
Is
acquired.
is taken out.
Oh, that is a formal acquisition department not been
That
acquired.
is admitted.
It's admitted position.
Representation same date.
Same date.
এটাতে ওই status report submitted on behalf of the state respondents is taken on record. বাকিটা same order হবে। 17, 20, 21, হ্যাঁ? Same order. Same order.
Much of
My application number.
Sir? Have you served, Mr. Shamanti?
Yes, yes.
Mr. Debra is appearing in this one.
Which matter?
Contempt application.
I'm appearing, my lord. I don't
You are appearing in the writ petition, not in the
know.
contempt.
Oh,
What's the contempt?
Go to food. The content number 1. It has been changed.
So you have to change the host title.
Because now, because of the election, ad hoc measure, district magistrate is there, madam.
But this is a
Your
contempt
lordship
application.
kindly adjourn the matter for some time. Otherwise, my lord, before election,
Or maybe the person will come back again after election.
when the district magistrate will be appointed, somebody has been appointed, but not ad hoc measure because the election.
temporary as per direction of election commission, my lord. Bardhaman, Purva Bardhaman and Birbhum, my lord, had changed.
Let me adjourn the matter for some time.
My lord, kind.
On your prayer, Mr. Shamanta?
Yes, yes.
Affidavit of service. On prayer of the applicant petitioner, the matter is adjourned. Paragraph. Petitioner, comma, let the matter appear under the same heading on 10th May. Next.
Report time. হবে না
Respondents?
In this matter, Mr.
My lord,
Hearing for the state matter is engaged before the Honorable Justice Rajesh Manta, and I claim for now.
My lord, I am filing the affidavit in opposition of the exception given by the petitioner in both the matters.
Affidavit in opposition to the writ petition.
No.
Exception filed by me.
Exception filed by him where he has taken certain point against me. And I have taken the leave on last occasion from your lordship that I have to file an affidavit to that extent. Or your lordship kindly see the last order.
Have you received a copy? You want to file a reply to this? Not necessary. But I think Mr. Sen is not there today. Mr. Chatterjee, let it be adjourned for some time. Mr. Sen is not there.
Yes, Mr. Sen is not there. I have seen him after recess in this close.
Some other court. That is what Madam said.
Mr. Sen is additional competitor. He is very busy. His juniors may be ready with the matter. It's not the way to adjourn the matter, dragging the matter.
Please do not make this submission because he is generally present in court every day. Today is an exceptional day when he is not there. He is present in court every day. It's not that he never comes. And the petitioner is not aggrieved.
No. Petitioner is not aggrieved because I am also not aggrieved because I am operating the vehicle. But the problem is this, today, somehow or other, I am free. Next date, if I am engaged, I cannot be there.
You admit that you are also busy like Mr. Sen.
No doubt about it.
Make this,
No doubt about it, but not like Mr. Sen. Sometimes he is regularly engaged.
All of you are very busy lawyers. So if we do not accommodate,
Very well.
we take up matters.
Very well.
I challenge the selection process.
So, both the matters, Mr. Sen is there?
No, my lord. Second matter, my lord, Mr. Devra is.
Oh, very good.
801, my lord.
Yes?
801, I am appearing.
Two matters are adjourned, my lord.
Point involved will both the matters same.
So let this also be adjourned.
Yes. Lordship, kindly make it on.
Let the
I
have no difficulty, but Mr. Sen is there.
I am filing the opposition.
You have filed already.
Another
Next
801.
Affidavit in opposition submitted on behalf of the private respondents is taken on record. Paragraph on prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 8th April.
Yes. Yes. Yes.
8th April.
Next, affidavit of 801.
801.
Affidavit in opposition submitted on behalf of the private respondents is taken on record.
But in both the matters, my lord, I have received the affidavit filed by Mr.
Yes,
Sen.
yes.
Well, a copy.
You don't wish to file a reply to any of the affidavits.
Well, a copy of the opposition be served upon us.
Yes, yes, we have
Upon
also
my learned junior.
Served?
Yes.
Served.
served.
Heard learned
Scan করে
counsels for
পাঠিয়ে
the
দাও।
parties.
না না স্ক্যান করে পাঠিয়ে দাও।
The paragraph, let the matter appear under the same heading on same date.
On 8th of April.
8th of April, both the matters.
My lord.
My lord.
Next.
This matter relates to the flying of the buses through Bardhaman town.
Exception clause.
Exception clause. Lord, on the last occasion.
Yes, Mr. Sen is appearing.
On
You ready?
23rd of February.
Lord, last occasion you
an order.
pass an interim order. Interim order.
order
to extend.
But the
Interim order be extended.
to pass the interim order.
You are not ready today.
And they are to file the opposition. On the last occasion, they sought to submit that they will file the opposition.
Instructions.
Subsequently, on 1st of March, it is to extend the interim order. The respondent sought for time to take instructions.
Respondent is again seeking time, so let the interim order. You are not ready. You are
I think respondents who filed the affidavit in opposition dealing with the issue is required.
They wanted to
for
take
adjudication.
instructions in the matter. Why opposition? Opposition is not required. Why prolong the matter unnecessarily? And you are
I am
not
not-
prejudiced. I'll
but
accept your interim order.
But as I remember, on the last occasion, Mr. Sen sought to submit an affidavit.
No.
As I remember.
He said
Might
he
be.
wanted to take instructions.
Very well. আমি এফিডেভিট দেবে না তার যা বলেছে তাই বলো
Let the matter extend the interim order and fix a date for hearing.
On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 9th April. 9th April.
My
Mr.
lord.
The interim order may be
My
extended.
lord, there is bunch of matters, my lord. I was also there, my lord, some of the matters.
The
I-
interim granted earlier is extended till 30th April or until further orders, whichever is earlier.
And my lord, the next two matters, the similar order may be recorded. Similar order may be recorded.
Who is appearing?
Lord, next matter, possibly Mr. Devroy.
Let me call. Mr. Roy, let me call the matters. 803, Mr. Debroy.
No. 803.
It is identical matter. It is identical matter. Lord. Similar order be governed with this matter so that all the matters can be heard together.
There is no interim order in this.
Lord, that is not been
No.
recorded. Although we submitted the similar order
When
may
it
be
is
recorded.
not recorded, it is not
Lord,
there.
you also kindly see. Lord, you also kindly, if for any reason the bench is changed, then we will be in difficulty.
No question of changing now. First
No,
of all.
I'm not sure.
9th April, lordship kindly bunch of matter fixed on 9th April.
Unless
That
the
will
order
be
is
better.
recorded, my lord, we will be facing difficulties.
Please be ready on the next. 9th April is a short date. Come
Lord, your lordship
Short
kindly
date,
record-
very
Time of the
Your lordship kindly, your lordship's desire was to pass the similar interim order
desire and
on
order are
identical
different.
matters.
I have a lot of desires. I cannot express everything in the order.
My lord, in first matter, your lordship is pleased to pass an interim order, and all the matters are identical.
Roy, since it has not been passed, come back on a
Today-
9th.
today-
I'll
today
consider.
I am placing for
I'll consider.
passing the same interim order.
In
I'm-
absence of the state is asking for
Lord,
adjournment.
This is the third occasion they are asking for time. This is the
Please
third
be
occasion.
ready on the next occasion.
But this is the third occasion on the same cause of a
Please correct. Please be ready on the next occasion.
My lord, up to 810, identical matter, lordship will adjourn till 9th.
On prayer of the state respondents, the matter is, on prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading, same issues or same date?
Same issue, same date, same Badawan,
Same date, 9th.
exception clause.
Next matter,
804, my lord.
804, I am for the state. my lord.
Lord, I am for the petitioner. Lord, I am, Lord, the similar interim order may be recorded in this matter, Lord. Identical matters, same order passed by the DM, which is under challenge.
there is an interim order in
Yes,
this case.
this one is interim order.
There is an interim order.
Then it is all right. Let it be extended.
Yes.
There is an
Let
interim
it be
order.
extended.
Not ready?
But let it be extended on the next day, my lord, sir.
All in
Right.
holy mood today. No one, the state
Either matter, my lord,
After 9th.
one day.
My lord,
on
only
prayer of,
first matter is interim order is given. The other matter there is no interim
so
order.
this order,
No,
this
yeah,
matter,
it
there is an
is.
No,
interim order.
these are the 2 or 3 matters, interim order
Are
is there.
one by one, so that there is no confusion.
That is better, that is better.
On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on same date, 9th March. Paragraph, 9th April. The interim order granted earlier is extended till 30th April or until further orders, comma, whichever is heard.
30th April, my lord.
30.
ছাড়
Next,
Yes.
I am for the petitioner, my lord.
We are for the state, my lord.
Identical issue, but in my,
please help me to dispose of all these matters on the next date, Mr. Botobel.
yes. Well, in my matter, my lord, the exception clause, same issue, I am praying for interim order in terms of prayer.
State,
State, my lord, Mr. Devra is appearing.
105, I am
805.
805, you are
I am
appearing?
appearing.
My lord,
Interim order in terms of prayer.
I do not.
Well, exception clause,
If everybody enjoying interim order, why he is barred from interim order? I do not know.
Oh, so I'm consent order.
No consent, no consent. I am not consent. This is lordship, is there. I am not at all, consent.
On prayer of the respondents, the
9th
matter is
April.
adjourned. Paragraph, the petitioner seeks an interim order.
prayer F, my lord.
দাদা এই পাঁচে আছে
Annexure 21, page 21, annexure F.
দিয়ে লিখে
In terms of prayer small f of the writ petition,
বলার দরকার নেই তো।
paragraph, the petitioner claims to be
এটা বোর্ডে দিয়ে নেওয়ার মুশকিল।
the petitioner is the holder of a permanent stage carriage permit in the route Kula, K-U-L-A, Kula to Nawabhat, and submits that
Paragraph 2, my lord. I have stated. Paragraph 2, your lordship can see page 4, paragraph 2. Entire alignment has been described, my lord. Important count.
paragraph 2 is your route.
The my lord, your lordship can see Kula to Nawabhat, via Makura More, Telegraph, Babu, Vivekananda College More, Sakari Pukur,
And claims that he
কি বললে?
covered by the exception carved out in the notification dated October 31, 2014, issued by the Office of the District Magistrate, Burdwan, Motor Vehicle Section, Government of West Bengal. Where is the impugned order?
Yes, yes, sir.
Page.
My lord.
Impugned order. Page.
My lord, impugned order. Your lordship.
48.
16 January order.
Yes, yes, sir.
48 page. 48.
Page 48, man. Page 47 it starts, annexure P7.
Memo.
The writ petition primarily seeks the petitioner primarily seeks clarification of the notification and assails the order passed by the District Magistrate, Purva Bardhaman on 16 January 2023. Paragraph, let the matter appear under the same heading on 9th April 2024. Paragraph, the petitioner is at liberty to ply his vehicle in terms of the permit issued in his favor till 30th April 2024. এটা এরকম করুন, let there be an interim order. Now, let there be an interim order permitting the petitioner to act. Next.
Same, yes.
Same?
Yes,
I'm appearing, my lord.
No order in this matter also?
Same.
The same order be passed.
Well, same. Similar.
807,
I am not appearing, my lord.
bad luck.
Some.
State is not there. Anyone for the state in 807?
Well, I
You've
served, my
been
lord.
served?
I saw, yes.
808. 807.
Yes,
807?
807 I served.
808.
Filed. Evidence service on the other day, I filed.
None. No, Mr. Sen is appearing. 807.
Yes.
This one here.
Let me go down. Okay,
3282. 3282, Mr. Sen is appearing.
807, Mr.
Let me
Sen.
807.
Mr. Sen and with.
Mr. Sen, no with.
Oh, yeah.
So he is not aware.
Kindly pass the same
No,
order.
I cannot. I have not passed in earlier cases. No discrimination. An accommodation is sought
Mr. Sen, I pass an order, I informed.
on prayer of the respondents. The matter is urgent. Paragraph, let the matter appear under the same heading on same date. 9th. It's a short date. Come back. Next.
Well, I'm happy for this.
Well, same.
Same order.
Same order.
Hey. On prayer of on Idulan. On prayer urgent date the fix. Next.
All four matters your law price.
809, I am appearing, my lord. 809, I am appearing.
809.
It's not identical matter, Lord.
809?
809, Lord. The route is Khudpuri to Nababhat. And
the same notification?
Same notification.
So then let there be an
same
interim order
points
since
of
you are
law.
appearing.
Everything
So
is
the
same.
interim order হবে.
He is enjoying, my lord. Let him enjoy.
Yes, Lord.
রুটটা নিয়ে নিন, ওইখানে যেটা চেঞ্জ হবে। খুদকুড়ি টু নবাবহাট, KHUD KURI, first second paragraph. খুদকুড়ি to নবাবহাট till 30th April.
Yes.
Next.
Yes. I'm state responsible.
Mr. Debra.
I am appearing.
Yes.
I am for the petitioner in this matter. The identical matter, Lord.
Same order be passed?
My lord.
Interim order to continue till 30th April.
A matter appear.
Shankari to word 1. SANKARI. Next.
Lord, I appear on behalf of the petitioner, my lord.
Yes.
Lord, this is the petitioner is engaged in the services of making and manufacturing
Who is the
e-vehicles.
I am appearing.
My lord, e-vehicles and the petitioner's vehicles are not being registered by the RTO, my lord. That is the writ petition. Your lordship has considered similar writ petitions, my lord. The facts are identical. The petitioner makes the batteries which are made out of a particular component, which is not lead acid battery, my lord. If your lordship recalls, my lord, in the similar writ petitions, there was a person who wanted to be added as a party, and there's a CAN application pending in this writ petition as well, my lord. My lord, we are not.
I'm for the.
We have a copy, my lord, here and now. We can give a copy.
Myself be added, and my lord, as your lordship has passed earlier these orders, those are the common orders.
Yes.
This is, I am agree with
Where
that.
is the application? Shantanu?
This is appearing.
It's Can 1
Can 1
Can
is
one.
an application filed by the
2024.
yes, my lord. Can 1 of 20.
Mr.
List আছে, list আছে না?
Mr. Mukherjee, when did you file an application? Recently.
দাদা,
When was it filed?
one minute বলেন। আপনি বলে দিন address appearing in the list. Please see it.
My lord, I have a copy. Can 1.
But I have filed the
वापस
I have filed it, and I think this matter also the Can 1 is appearing in that.
My lord, on the last occasion, when this matter had appeared, your lordship had adjourned the matter because of the Can 1 which was appearing in the list. So your lordship said,
Still not appearing.
Lord, may I suggest something, my lord? My lord, the Can 1 has been served upon us, my lord. My lord, we do not object to the Can 1 being allowed. My lord, the party.
To be on record.
My lord, I understand.
এসছে Can 1. Let him just find out.
My lord,
May I, my copy, may I?
I've handed over my copy. My lord, the only grievance, my lord, of the petitioner is that, my lord, the petitioner's job, my lord, the petitioner is a company engaged only in the registration of e-vehicles, my lord, and that is not being registered even after 2 communications made to the RTOs, my lord. Till such time any order is passed, my lord, the one copy file করেছে?
No, way back in February.
February
আপনাকে কবে সার্ভিস
দিয়েছি।
This doesn't challenge the notifications. He is
No.
only asking for issue.
I'm agreeing on the order which already your lordship passed. This common orders in respect of registration of
Lord, I am carrying one of the orders passed by your lordship, my lord.
Let me see
Lord-
what the order is about.
Yes, my lord. A similar order, my lord, may be passed for the petition.
যেখানে ওর মধ্যে মৌসুমী ভট্টাচার্যের যে একটা অর্ডার ছিল ওইটুকু ইনক্লুড করেছেন।
So yours is lead acid battery.
Yes, same.
No, my lord, not, my lord, thereafter also my lord has passed another order where your lordship clarified the coordinate bench where the my lord Justice Bhattacharya was passed 16th of February and thereafter 18th of February modifying the earlier order. And your lordships also mentioned those two orders. Here is not that, my lord, this order is not, my lord, thereafter your lordships passed another order. I think that's the order.
Perhaps, my lord, my
But that paragraph is stated in the last
yes,
page.
my lord, that is what I want.
So the order has not been referred to. This is what was stated in the modified order.
Yes,
So it will not make a difference.
my lord, I had cited that order. I had appeared in this matter also, my lord. I had cited that order, and your lordship had passed this order in pursuance of the previous orders passed by this honorable court. my lord.
Contempt. এই অ্যাপ্লিকেশনটা এসছে অ্যাপ্লিকেশনটা এসছে because I cannot keep this on record. This is your copy.
Yes, my lord. My lord,
Are you available on 27th? I'll keep it on 27th.
yes, my lord, I am available.
Mr. Mukherjee, 27th.
27.
So that I'll just make it not today in that case.
Yes.
So that I'll just get hold of this.
Yes, my lord.
আমি কি করবো আমাদের অ্যাপ্লিকেশনটা কোর্টের ফাইলে নেই আমার কাছে
এসছে কেন? এই it is-
ওনার কাছে রাখলেও হবে। আমার কি ভুল আছে লট অফ ম্যাটার অ্যাডজর্নমেন্ট ছিল না তো আমি আরে বল না আমাদের পুরো হিটিং না হয়ে গেছে এই আমার এই কেন না আছে ছিল ওরা ঢোকায় দিচ্ছে
So does this be allowed?
Yes, my lord.
The
Can one?
application,
Yes, my lord. I'll read it.
Don't it? And the same order is being passed in
Yes,
this
my
order
lord.
also. Can 1 of 2024 টা আমি করুন। The intervenor, the proposed intervenor seeks to be added as a party respondent to the writ application. On the ground that he is a necessary and proper party herein. Paragraph on consent of the parties, the application is allowed. The intervenor be added as respondent number
26.
25, 26 in the writ petition. Paragraph, the cost settle of the writ petition be amended accordingly. Can 1 of 2024 is disposed of. WPA the same order. I'm not repeating, I'll just pass.
Yes, deeply obliged.
Yeah.
My lord, may I seek return of the CAN application?
Yes,
My-
yes,
my
of course, yes. Copy টা করতে দিয়ে দিন।
Deeply obliged.
812. I appear for the petitioner in identical matter.
Yes.
Identical matter, except come under the exception clause. The petitioner is the holder of a permit in respect of Netrakhanda to
town bus service.
Bardhaman.
Other matters are fixed, not possibly on 9th of April.
9th April, it has been fixed. Let the similar interim order may be granted, permitting me to ply the vehicle in
Till 30th.
Till 30th.
Join the
আগেরটা করে নাও না
9th April until 30th April.
and the interim order may be continued
30th April.
আরেকটা ছিল না
আমি নেই, আমি এটাতে আছি।
না না 803
আরেকটা
ওটা আছে।
সেম মামলা
আছে তো আপনার কাছে।
এই মামলা এই হবে subject to lordship indulgence in 803 my learned friend is appearing for the state. No interim order has been recorded. Identical matter, similar interim order may be recorded.
Shall I pass the same order?
Because same matter.
Join
Matter.
Join the
803 milord.
803 interim order হবে। I'll record the same order.
30th, my lord. Till 30th.
Yes, yes.
Let all the matters be taken up together.
একসঙ্গে হবে হ্যাঁ
813
ঠিক আছে
petitioner
হ্যাঁ এই তো
Mr. Debra.
I am appearing, my lord. 813.
But the petitioner is a permanent permit holder on an interstate route. Your lordship will find at page 14.
Yes.
Where Rampur? Via Dumka, Rampur. Now, when a permit
Yes.
issued by the State Transport Authority, Jharkhand. Number it has to be countersigned. When I replace the vehicle, and your lordship will find and when I replace the vehicle, then when I pay the taxes that your lordship will find at page 17. ঠিক আছে তোমার নাম্বারই হচ্ছে the next page is the tax. They have received it. The State Transport Authority, this PVD Calcutta. This is the part of the tax which has to be paid before the State Transport before this state that I have paid. The counter signature has not yet been granted. And your lordship will find at page 21. Annexure P4.
Yes.
After my lord replacement, this renewal by the State Transport Authority Jharkhand that has also been granted. That your lordship will find at page 20. Page 21 and 1 P4. Now, my lord, after renewal, the Secretary State Transport to Jharkhand wrote to the Secretary State Transport to West Bengal.
That's
Your Lordship.
21.
Page 21. It is the my lord, the interdepartmental correspondence.
This has not been done as yet.
But that has not been done as yet. And then, my lord, I made also a representation.
That's a demand of justice.
Hello. My lord, that is not. Your Lordship will find page 27. Then the my lord, the
This is CS renew করার জন্য প্রার্থনা করছি।
my lord,
That's
counter
counter
signature.
signature.
So, my lord, then, my lord, your Lordship, thereafter, my lord, no, that has not been the countersign. No reasons has been shown as to why the counter signature cannot be granted. And my lord, this is pending.
But they have not said cannot be done. They have just not done anything.
My lord, that I'm saying that
Not
the reasons
refused.
has not been given as to why this has kept pending for a long and not counter signature cannot be granted. That has not even been. And thereby, my lord, this my vehicle, despite of my lord, the renewal of permit and depositing the taxes in respect of the state of West Bengal, I could not operating this vehicle.
Let us hear the state. Yes, Mr. Devgan.
Yes. Well, my specific instruction is well, the vehicle, well, till 2012 to 2016, he has not paid any tax. In spite of repeated reminder or notice given to him, my lord, he has not produced any documents relating that paper. Lordship, kindly see, my lord, Mr. Bandyopadhyay, my lord, Mr. Bandyopadhyay, so instruction, Lordship, kindly.
Yes, given.
Lordship, kindly see the instruction also.
Have you given a copy to Mr. Mukherjee?
Yes. No, only one copy of it. Well, Lord, he has paid the taxes up to
2012 to 2016. Lordship, kindly see the last portion. And he has been intimated by the Deputy Secretary then, by letter.
Letter also.
Up to 31st
2018, they have intimated.
2018, we have intimated, my lord.
12 to 16, she has not paid.
She has not given.
Yes, that period he has paid and he renewed the
Additional taxes also not paid, my lord.
So for the
Vehicle
reason
replacement.
it is kept in abeyance.
No, my lord, these my lord, the whatever be
It has been
allegations. But I
That
have
was all are intimated.
intimated, my lord. Kindly come to page
where
17.
where
Page
Let me-
17, my lord. At his application, my lord. Page 17. He has replied to it, my lord. Page 17. Why our letter dated? That has been in reference. He has written 29/2018. We have written to them. What he has done, he has only deposited taxes up to 31/8/16 to
He needs to be served this copy.
my lord,
Otherwise,
let
he's
me
not
have a
going to
copy,
take
my
out.
lord. I will be in dark, my lord. Otherwise, I cannot
Yes,
even.
yes, absolutely.
he has paid part taxes, my lord. Not
One,
the entire
only
tax.
one aspect, my lord. My lord, this may I use, my lord, the exception to this because of
Exception, you can take instructions.
oral submissions will.
This is not oral submission. This is the
No,
instruction.
my
Written
oral
instruction.
because it is his instruction in writing. So if I say something in orally, well, that's
No, you can always come back with an exception and you have to
or
annex.
exception or something, whatever it has been here.
Yes, you have to
So,
clarify this. You have to
well,
say that
clarify, and if I get some documents in support of my
Yes.
intention, then I have to file it by way of a supplementary affidavit.
without documents, it will not help because they
My
say
lord,
you have not paid.
that I am because that documents cannot be even placed without verifying by way of an affidavit.
No. So you'll come with a
Yes,
an
yes.
exception.
On this file.
Affidavit of service.
আমি এটাতে তুলে আপনাকে দিয়ে দিচ্ছি তো তুমি ছবি তুলে রাখবে না
The petitioner
ঠিক আছে
complains that though her permit was renewed by the State Transport Authority, Jharkhand, the same has not been countersigned by the State Transport Authority, West Bengal.
তাহলে এটা
Till date. Paragraph. Learned counsel for the respondents submits instructions of the Secretary, State Transport Authority, West Bengal, which demonstrates that the petitioner has failed to produce any tax receipt showing payment of tax from 30th November 2016 to from 1st April 2012 to 30th November 2016, for which the renewal of countersignature of her permit was kept in abeyance. Learned counsel for this petitioner seeks to use an exception to such instructions. Paragraph, let the matter appear under the same heading on 15th April. Please serve an advance copy.
Now, my lord, your lordship, kindly, my lord, in the writ petition itself appearing, they are saying that till November 2016. Well, here, my lord, the 29th August I have deposited, the receipt has been annexed with you.
But he has deposited a part.
A part.
12 to then in fact 12 to July.
That I will.
2012 to July 2016. Next.
Much obliged.
And this one I coming on behalf of the petitioner, on the matter relating to my lord e-rickshaw.
I am appealing for the state led by Mr. HON'BLE.
You're ready?
Yes, yes.
For similar order, I've annexed on 13 July, 13 January 2022, and also
What is your case? What is the matter about?
the e-rickshaw.
E-rickshaw registration.
Yes, yes, same. I discussed this one. Just I placed the document. I've annexed my lord the.
E-rickshaw is still continuing.
Yes,
yes, yes.
My lord.
Oh, my lord,
Same.
Same thing.
My lord,
13 July and 13.
My lord, here I joined the issue, my lord. Here, my lord, I have made a party. I am a party in this writ. Now, my lord, these writ petitioners filed another writ petition. And that matter has been suppressed in this writ petition on the same cause of actions. My lord, I have got this copy.
On the same cause of action.
My lord. And I have got this copy, my lord, that even not a single line in the present writ petition.
Yes,
This is
Mr.
all
Khan.
my lord suppression of that.
Identical
Black-
petition
my-
filed by you.
It
is, my lord.
Please give him the number.
দিন আমি দিয়ে দেবো কপি দিয়ে দেবো আপনাকে কপি দেবো আপনি কিছু বলেননি দিন ওই একই পিটিশনার দেখুন না কি আছে মানে the petitioner is EFEP Charging Solutions Private Limited.
Mr. Khan,
With the same because I don't know because I have no
take
construction.
instructions and come.
Yes, yes, I see.
That
copy there.
Let him take instructions.
আমি আপনাকে দিয়ে দেবো কপি because আমি just I have
Numberটা
read number
Read number down.
Solve numberটা লিখে নিন।
but the read number the earlier petition read number is my lord
Affidavit of
WPA
service.
লিখে নিন।
It is submitted on behalf of the private respondent
উপরে লিখে নিন।
that an identical writ petition was filed by the writ petitioner
26508
26,508.
26,508.
Of 2020.
It has been disposed of.
Well,
The
of
WPA,
Well, WPA number 26508 of 2023.
yes, sir.
And that
2023,
ওটা দেখে ওটা আছে
on the same cause of action, which has been
perhaps one of
disposed
your
of by an order passed on,
that copy, perhaps your lordships has passed an order in this regard.
which has been disposed of. Paragraph, learned counsel for the petitioner seeks to take instructions in this regard.
আপনারা short date so that I can take.
Yes, yes. Paragraph, let the matter appear under the same heading on 9th April.
9th April.
Next.
Private respondent.
Yes, respondents,
I am for the petitioner.
respondents.
This is service.
Time for the state minor led by Mr. Sen.
Have you served the private respondent? Who is
Yes,
appearing?
yes.
You are appearing?
Yes, Mr. Mukherjee is appearing.
But I am happy.
Yes.
Now, my lord, here the allegation is that the private respondent has been granted permit by the Regional Transport Authority, Hooghly. Regional Transport Authority Hooghly, in violation of, in respect of the route Tarakeshwar to Bankura, in violation of Section 69(1) of the Motor Vehicles Act, because major portion lies with Bardhaman, and in violation of the notification issued by the State of West Bengal on 8/3/2013, where it has been categorically indicated that where the major portion lies, the RTA of that area will be granted. Now, the only thing what I am praying at the present moment, because this permit has been issued in 2019. This is 2024 and it will end in 16 September 2024. Not beyond it. Now, I have made a representation before the authority concerned through the advocate concerned, that is at page 26. Page 26. Now, this objection I have raised through my advocate that the grant cannot be made in view of this. Although the permit is going to expire in September 2019. So, at the present moment, I am molding my prayer that for this rest 5 months, no disturbance is required. When they will renew the same, they will decide my objection and take into consideration the notification at page 25 and section 69(1) of the motor.
Why are you so kind to the private respondent?
My lord,
Why are you so kind? to the
because my
private
lord,
respondent?
it is now end 24. Your lordship kindly come to page 22.
You say September 24.
September 24, yes. March is end. April, May, June, July, August, September.
Sometimes my seniors always, it is not the case, this is always.
No. Now, my lord, up to 2.5 months, the government offices will be busy for election. Up to July. Then only August and September is left.
Very candid submission. Very candid submission.
So why shall I disturb him? He has applied for 4.5 years. Let him complete another 6 months.
Mukherjee will give you a treat today. Don't worry.
My-
Yes, Mr. Sen.
I have learned from him also, my lord. In my early days, I have learned from him the motor vehicle. So I know.
We deal with a subject where we learn every day. That is my
Well,
personal.
each and every day. Each and every day.
My lord, in the midst of their, my lord, the arguments, my lord, I just, my lord, entered. And my lord, if it appears that, my lord, that anything, my lord, in, my lord, the modified way, he, my lord, made anything, my lord, so far is, my lord, the allegation and or complaint is concerned, then let it be done. But so far the authority is concerned, my lord, if my lord direct the authority can consider this representation.
The petitioner's prayer is very innocuous.
Yes.
He says, let the representation be considered at the time of renewal of the permit. Since the permit will expire in September this year.
My lord,
So, he doesn't want to disturb the private respondents flying till September. When the permit is renewed, let this be considered.
then my lord, a fresh representation has to be made. Because my lord, may I tell one thing? Because so far this representation is concerned, this is my lord, with regard to the my lord, the period of the my lord, the present my lord, the validity period of the permit. Now, my lord,
It's with
in
regard
the
to
interagnum period, let's kindly consider one thing. In the interagnum period, when my lord, this permit going to expire or after expiry and another permit is to be issued, then my lord, during that
Very well,
period,
my lord. Then they
so
will
my
let them consider as it is today before the election.
I have
have no problem.
I have no objection, whatever fell from your lordship or on the basis of his prayer.
Going to merits of the matter at all.
Yes.
I will only direct the authority to consider the representation.
Yes, very well. Let them do it.
take the
Yeah, because
necessary
no, only thing.
Why I say this, Malad, may I tell?
Strategies
Malad,
is cancelled.
Malad, I have
Yes,
Your
Malad,
leave
that,
is cancelled.
Malad, yes, that.
Or
Malad,
only
that
thing,
if
when
it
they
is
will
before
consider.
elections, Malad, this will.
No,
change,
Malad, before or after election, may I
No,
tell
no,
you
not
one
not
thing?
on-
Just a minute. Malad, may I tell? Malad, if the order is passed by your lordship that at the time of consideration of the renewal of the permit, Malad, this question would or this issue, Malad, would be considered. But there is every possibility that may be left out from there, Malad. Lordship kindly consider one thing. Because then Malad, a contempt proceeding would be.
Because
Then
in
yes.
September,
Yes.
Very well.
Then, my lord, a contempt proceeding would be filed that year. So I do not want to that, my lord. So that is why I say either let him withdraw this, file, my lord, his my lord, because
No.
or my lord, let it be as it is here and
Very well.
Direct.
Let them decide this objection regarding their grant of permit in violation of the statutory position, as well as your lordship can come to page 25. Page 25, as well as in violation of this notification. So, my lord, now at the that's my precise prayer also. Your lordship kindly come to my prayer A, that at the time of consideration they let them. Yes, your lordship kindly come to prayer B. Yes, prayer B.
অসুবিধা হবে ফাইল থেকে বেরিয়ে যাবে সবার বেরিয়ে যাবে তারপর কন্টেম্প ফাইল
Prayer B. So let them do it as early as possible.
Mr. Mukherjee, you'll be given an opportunity of hearing. Let them consider. I'll not
Yes.
state anything on merits.
No, I'm not asking for any stay also.
Yes, Mr. Mukherjee.
Well, a reasonable time be given so that the notice can be served upon all the interested persons and matter can be taken up.
But only, in that case, Malad, I must say, Malad, this cannot be said, Malad, page 26. Though my learned senior told that this is a representation through the learned advocate, but this cannot be treated as a representation at least. But this is your lordship kindly.
I generally do not allow
My lord always
demand of
always
justice.
asked to make
So
a
why don't you-
representation
why
by
don't
the
you submit a
by
comprehensive
the yes,
representation?
ma'am. Yes.
Why don't you submit a representation before the authority? This is a demand of justice.
This is demand of justice.
There should be a representation before the authority, not a demand of justice.
Or other objection.
As your lordship pleases, there is no there is
Actually, Mr. Chatterjee, in other matters, I do not allow this.
very well.
So why don't you come up with a comprehensive representation before the authority? The same
Or
amendments.
or if they take into that, I may not place that. I will say that the grant of permit is itself is illegal in violation of that. Your lordship kindly decide that. Then where Mr. Mukherjee will stand.
Malad, in that event, I have to
I think
grant
why
an
don't you
opportunity.
file a fresh representation before the authority? Yes.
Technicalities are technicalities. If the technicalities are there, then Maran, I'll say that don't look into that representation or
Comes on merits.
do a representation. Now, your lordship kindly consider whether the grant at all is tenable or not.
So please do not counter technicalities on merits.
And my lord, what would happen in that event? He must say that I shall file an affidavit. Because without affidavit, then when the matter would come up before your lordship, then after exchange of affidavit, then petition would become infectious because the period or life of the permit
will automatically expire.
Very well.
Actually, you're coming with the
Your lordship kindly give me some time, 15 days time, so that representation can be recouched and send it to the authority, and authority will consider the same after
The same amendments only by the petitioner.
after receiving the same within a month or
Consider, yes. Affidavit of service.
My lord, kindly, only thing, my lord, kindly take note of the, my lord, the present situation, that, my lord, the election.
Now.
I'll give you some more time.
Yes.
So ultimately, the prayer will be the same, like, let us see.
Yes, what my learned senior friend told earlier, that ultimately goes to that period.
The petitioner
September.
complains that for
Election
has
is
been
September of the
in favor of
think
the
so.
private respondent
Result September.
in violation of section 69 within bracket 1 of the Motor Vehicles Act 1988 and the notification issued by the Principal Secretary, Government of West Bengal on 8th March 2013. Stop. The petitioner seeks to submit a comprehensive representation in this regard before the concerned authority and prays for a direction upon the authority to consider the representation at the earliest. Paragraph, who will consider? The board.
Board.
Second respondent.
Second.
Learned counsel, paragraph, learned counsel for the respondents submits that the second respondent be directed to consider the representation at the in accordance with law. Paragraph, in view of the above, the writ petition is disposed of with liberty to the petitioner to submit a comprehensive representation ventilating his grievance before the second respondent within 2 weeks.
Before the third respondent, district magistrate.
Who will deal with it?
It will be board headed by the district magistrate.
So let it be the second respondent. That is the board.
Yes. Second respondent is the authority.
Yes, that the, my lord, when it's a question with regard to, my lord, the legality of the grant of permit and as well as the authority, then, my lord, the regional transport authority.
Yes, regional transport authority will do it. There's no doubt about it. But the representation addressed to the district magistrate will go the board.
No. District magistrate is the, my lord, the chairman. My lord knows very well. But the board is the, yes.
Not in his personal capacity.
Yes.
Second
Very well.
respondent within 2 weeks.
Within 2 weeks.
Within 2 weeks from date. Stop. The second respondent is directed to consider and dispose of the representation within 2 months.
Within 2 months.
Sufficient. Within 2 months from the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioner and the private respondent, in accordance with law.
But within 2 months from the date of communication, from the date of receiving,
date of receipt. Only thing, my lord, at the time of consideration, he will consider the statutory position as well as this notification.
In accordance with law.
And you can hand it over to him.
Everything.
The decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of which actually.
Get.
Affidavit of service will issue. Next.
দরকার নেই পারমিট শেষ হওয়ার আগেই শঙ্করের পারমিট ক্যান্সেল হয়ে যাবে
Yes, 816.
I'm for the petition.
Well, I'm appearing for the district.
Yes. Yes, Mr. Mukherjee.
Well, when I am a permanent permit holder, well, the route is Shona Konya. Your lordship will find that the copy of the permit is at page. Is at page 23. Number, this is route. Page 23 is the permit. Well, serial number 3 is route. Shona Konya to Kornamoi via Sudansu. While I made the application for renewal of permit, that is at page, this is a renewal application. That is at page 27. Page 27. This is an inter-regional route, madam. This was, madam, this is the applications through, madam, online mode. Then, madam, the next page is, madam, the representations in short form. It's made for. Then, madam, this was. What is this? Madam, page 29, your lordship will find the vehicle was under a hire purchase agreement with Punjab National Bank.
Yes.
The vehicle for which the permit was granted, the vehicle was under a hire purchase agreement with the financier bank, Punjab National Bank. Now, madam, the provisions is there while renewing the permit, a no objection required from the financer. Now, madam, as your lordship will take up these Motor Vehicles Act, section 51. Section 51, subsection 6.
Yes.
The registered owner shall, before applying to the appropriate authority for the renewal of a permit under section 81. This is section 81 is in respect of the period and renewal. Section 81 or for the issue of duplicate certificate of registration under subsection 14 or section of section 41, or for the assignment of a new registration mark. So let us skip over. This first line for renewal of a permit. Then last but one line. Make an applications. Last but 4 line. Make an application to the person with whom the registered owner has entered into the said agreement. Such person being there hereinafter to set the said sections 24(2) financer for the issue of a no objection certificate. Now, it has this appears from these provisions that while renewing, if a vehicle is covered under a hire purchase or lease or hypothecation, then I have to obtain a no objection from the financer and to place before the authority for renewal. Only here it has come to a reverse position. Now, your lordship will find at page 29.
Yes.
Page 29, your lordship will find that this is a memo issued to the Punjab National Bank. But this body is that this is to inform you that the name of your company, organization, so and so has been endorsed in the registration certificate of the vehicle with registration so and so. The registered owner of the above mentioned vehicle has applied for renewal of permit bearing number so and so. If you have any objection regarding renewal of permit of the said vehicle, then please so and so. Now that in respect of subsection 7 of section 51. Now, your lordship, these later issued on 17/1/2024. Now, I made the application that your lordship will find that at page 27, 12 September 2022. That is the top. They have received.
You produce the no objection certificate to the authority.
No, this I am coming. The section refers that I have to obtain no objection. And that if I fail to obtain, the provisions say fail to obtain is not there, then I have, your lordship can see to make an application to the person, the registered owner, before applying to the appropriate authority for renewal of permit. Now, this has to be done by the application has to be made by the permit holder to the financer to get the no objections. This is section 6 says, not the 7. Now, subsection 6. I will also kindly come to the 7. Subsection 7. Within 7 days of the receipt of an application under subsection 6, the financer may issue or refuse or reasons which shall be recorded in writing and communicated to the applicant to issue the certificate applied for, and where the financer fails to issue the certificate also fails to fails to communicate the reasons for refusal to issue the certificate of the to the applicant within the said period of 7 days, the certificate applied for shall be deemed to have been issued by the financer. So, my lord, there is also, my lord, a clause which, my lord, if it is after 7 days, even if I apply and if they fails to send the no objection or by whatever reasons that they will raise the objection in renewing my permit, that has to be, my lord, sent or communicated to the applicant within a period of 7 days. This is the, my lord, the provisions enumerated in the act. But here, I have not applied for. Now, they themselves wrote to the financer.
Yes.
It was mandatory on your part to apply before the financer for a no objection. The provision says so.
But I'm coming to that.
It is a shall, it is not a may.
That's right. Well, I'm not on that. Now, they wrote to the authority or the bank financer. But I haven't any knowledge what has been given. Now, subsequently, I am filing a supplementary affidavit wherefrom I got my the Punjab National Bank on 22nd of January this year, wrote to the authority directly. Even this is not the copy but I am submitting one of this. This has been come later on.
Have you served the copy? You received
Yes,
the copy?
madam, sir.
Second page second page আছে this has been sent to the regional transport officer, state transport officer, so and so. Even I didn't have the copy. Even the copy has not been forwarded to me by the bank, whatever be the reasons, I don't know. Even I have to collect it, and it will take at least, because that has been wrote to them and this has been given to the authority itself, but the copy has not been served upon me. Now, one aspect which has to be dealt with, কি বলে দিয়েছে গুগলে কি দিয়েছে as your lordship have
Your prayer is only for issuance of renewal of permit, isn't it?
renewal of permit. Now, your lordship kindly come to this. The reasons the bank has stated here that because of this, they are not in a position to issue the no objection. That one aspect. But therefore, we request you not to renew the permit until the overdue NPA amount is not recovered by the respective. This is an issue which is between the bank and the owner of the vehicle. That has not been if assuming the financer give the reason for refusal to issue the certificate as applied for no objections. In that event, what will be the remedy available under the statute, that is not here. So, matlab, these no
The
objection.
remedy is very obvious. You have to pay the amount, clear the dues.
No, matlab, that in my, matlab, my respectful
In fact, the
submissions,
petitioner
matlab, I
has
shall,
tried
matlab, I
to
shall.
like the permit without clearing the dues surreptitiously.
Well, this is not where.
The mandate has not been complied with.
My lord,
The provision mandates application of a no objection.
application,
Obtaining application
certificate for no
yes.
objection from the
That
financer.
was not done by the petitioner.
Now, matlab, that has been done by the authority. The part has been
Irrelevant,
carried out.
irrelevant.
Matlab,
The
What
that,
is wrong?
provision. That is wrong. The petitioner has not complied with the provisions.
so that is there,
So
my
he
lord.
is in any event not entitled to the renewal.
My lord, your lordship kindly appreciate that I am not on this because this is very clear that
Because your
they-
only prayer
this
is
is
for
the-
renewal.
my lord, that apart.
You have no other prayer.
My lord, that is not issue. Issue is here, my lord. What I am submitting, that I am asking for renewal, and where, my lord, the no objection certificate is required from the financer if the vehicle is under a hire purchase or hypothecation. Like, my lord, in any event, if the financer do not issue such certificate, rather refusing to grant the certificate, saying that these are the reasons for which I am not granting the no objection in renewing the permit. Whether that can be, my lord, that can be taken into consideration in renewing the permit or not. Where it has been now, where it has been, my lord, stated, my lord, your lordship kindly see. If, my lord, that should be, my lord, that should your lordships, I will produce, my lord, the judgment therein. Also, my lord, I will
Judgment.
my lord, argue. Yes, I will argue on this aspect. Assuming no objection certificate has not been granted, or rather refused to grant on a specific grounds. Now, is it the remedy what they have stated that in a way, or whether that will prevent the authority in renewing the permit? Where is that provisions, my lord, is there?
Mr. Mukherjee,
But I am not on that. I am not on that.
it will
Whether I,
prevent
whether
the
I,
petitioner
if I,
from applying.
Yes.
The
Yes,
authority
this is
later on, that is subsequent.
correct.
The petitioner cannot apply without a no
Never
objection.
approach.
If the petitioner applies for no objection and that is not granted, then it has to be taken
no,
that it is,
no, my
it
lord,
is
that
given.
is not grant. Not only that, my lord, there is
But where
two,
is your
two aspects.
application?
My lord, only one thing. My lord, this, but the facts appear that is two options is there. Either they have to grant no objection, or they may not grant. Then in that 7 days comes into effect, or they
He never
refuse to
approach.
grant, giving such some reasons. Here, what happened? These facts arises that they given these reasons that the permit cannot.
Yes.
The authority is directed not to request not to renew the permit until so and so. So, my lord, they have given the reasons. Now, whether the authority relying on this and where is the provisions laid down in the acts, my lord, that has to be considered.
Mr. Mukherjee,
That-
even if that is not considered, I hold that authority has no power, no authority. Does the petitioner?
I am not on that. I am not.
Apply?
I am not on that. I am not on that, my lord. Assuming one has, well, this is not the case here. Assuming one has applied for and the bank has refused to grant.
Assume at all because it has not been applied for.
My lord, these issues comes as well. The facts remain same. Facts remain same because it is an NP account, non-performing.
Let me pass an order.
No, my lord, this I need to, my lord, this on this I need to, my lord, argue on other points are there, my lord.
More
Let-
unnecessary waste
my lord,
of
my
time.
lord, never I, my lord, I always withdraw, even the writ petition be withdrawn as your lordship, so things necessary. But here, my lord, the point is there, my lord.
He never approach.
If your lordship,
He
not
never approach.
The sole point.
That's whole point. He never approach. Since 2022, he never approach.
Applied for renewal without approaching the financer first.
my lord, be that as it may, my lord, I on that issue, be that as it may. Facts comes that the bank has straightway rejected,
Rightly.
Rightly done.
not on that, straightway rejected and said that this permit can, you requested not to renew the permit as because the the accounts of the applicants
Yes, it
is
has become
in
NPA, yes.
non-performing assets.
Yes.
Become a non-performing asset. Now, but I am on this, on that they requested whether the authority, on this aspect, whether the authority adhering this request, the power is there not to renew. But that has to be considered. But
Primarily, whether you could have applied before the
that
authority.
I also.
That is the primary question for
51-6 has
consideration.
not been complied with, my lord. 51-6, he has not complied.
That is the
issue.
it is fallen from.
Finally, my lord, on that aspect,
I will give you a chance to develop because I have expressed my mind.
no, only
There
one
is
day,
no
my lord,
case.
your lordship. But that the
Question of pending, my lordship.
Let him come back with instructions. Since I'm bent on dismissing, I should give an opportunity.
No. That. Lordship.
Supplementary affidavit submitted on behalf of the
sometimes, my lord, these
petitioner is taken on
section
record.
51, subsection 6 and 7. This is not, my lord, within the, my lord, I know the ignorance of law is cannot be an, my lord, that I know. But the people, those who are operating, my lord, that I know that it cannot be taken an issue.
Application was not made by the person who was operating.
My lord, that I have seen. But it has been the liability taken by the authority to send.
Rightly.
You can. But it will not help, Mr. Mukherjee. I must
That
be
I
very
will
clear.
I will try, my lord, I will try, my lord, next day I will try. If that
Counsel for the petitioner submits that he had applied for renewal of his permit
তোমাকে তো বলে তুই বললে
before the
নরমালি ওরা বলে
না, এর আগে একটা লাইন করুন।
রিনিউয়ালের সময়
It is
আমাদের একটাতে বলেছে
submitted on behalf of the petitioner
তখন দেখেছি
that
ওটা রিনিউয়াল
the petitioner is the holder of a permanent stage carriage permit in respect of a vehicle which was purchased under the hire purchase agreement, under a hire purchase agreement. Stop. The petitioner approached the respondents for renewal of his permit pursuant to which the regional transport officer, West Bengal, by a letter issued on 17th January 2024, requested the Punjab National Bank, Potashpur, Koshba branch, Purvo Medinipur, to inform whether the bank had any objection regarding renewal of the permit. Stop. In reply thereto, the bank, by a letter issued on 22nd January 2024, informed the authority that requested the authority not to renew the permit till the overdue NPA account of the petitioner was not recovered upon payment of the entire dues by the petitioner. Paragraph. Learned counsel for the respondents submits that the application for renewal of permit was made by the petitioner in contravention of the provision laid down under section 51 within bracket 6 of the Motor Vehicles Act 1988. Stop. The petitioner ought to have applied before the financer for issuance of a no objection certificate in terms of the said provision prior to applying for renewal of his permit. Paragraph. Learned counsel for the petitioner seeks to take instructions in this regard Paragraph, let the matter appear under the same heading on 10th April. Next.
আপনাদের বিশাল খারাপ May it please your lordship, my lord. I am for the petitioner. Now this is my service. Now before I make my submission, my lord, in a similar matter, the lordship had disposed of an application. My lord, where, my lord, I am relying upon your lordship's judgment. It is the next. My lord, this is my service. My lord, this is a case where petitioner company is engaged in the business of manufacture and sale of electrical vehicles.
You're appearing for all the respondents?
Yes, please. And including e-rickshaws, my lord, since 2016. My lord, it's a battery operated e-rickshaw, as your lordship knows. And so far as my lord, rule 126.
Mr. Mukherjee, you have not been added in this case.
My lord, I have filed the application, my lord, intervention application, that is also appearing, I think so, my lord.
Have you received a copy of the
My
intervention?
lord, the-
Well, I have not
appear-
received.
When did you,
And Lord,
But this, my lord,
when did you file?
Lord, I need also instructions, Lord, because I have already asked for instructions. Lord, Lordship, kindly give me some time.
Let the intervention application be considered.
Fine.
first.
And your
third
Lordship.
of, my lord,
Shantanu, Intervention.
my lord, I, 23rd of
copy
February.
দেবেন ভাই।
That is, I think.
When did you file, Mr.
আরে
Mukherjee?
দিন না কপি দিন না একটা
হ্যাঁ, কিছুই না।
আরে আমি জানি আমি এগুলো করছি আমি জানি না
When did you file?
But 23rd of February.
ওনাকে একটা দিন
23rd February.
এই আমাকে একটা কপি দিন।
And my lord, the same issue, your lordship has already disposed of
Similar.
several matters.
similar.
No, but the.
I don't know
the
what my
state
lord,
come
no,
back
no,
with
no,
instructions.
I agree with you. My lord, let him also, my lord, take instructions, but
So
similar.
shall I allow the intervention application?
Yes,
It's
yes.
Not in the file
My
today,
lord.
that's difficult.
My Lord,
It has to come to
Your
the
Lordship,
file.
your
My
Lordship
lord, my lord can record that where the file was not there, so upon request, the learned advocate has handed over a copy which was
The
given.
original application has to come.
Yes.
that
And
is
my lord,
clear,
this
Lord.
is appearing in the list, can one.
It is appearing in the list.
My lord can have a look.
Amlan?
It should be there, my lord.
Shantanu, দেখতে
আচ্ছা আমি যে judgment-টা দিলাম ওটা দিয়ে দেন সাথে?
Please give me a minute, I'll just find out. So that I can dispose of this.
আমি দিচ্ছি। না, না।
And I have relied upon your lordship's judgment.
Several hundreds of judgments have been passed on,
to receive.
but still let the state come back with instructions.
And the all orders
This
after my
matter
lord,
has been filed long time
Mahindra
back.
Mahindra's
I don't know why the
electric
instructions are
mobilities, they are after these all orders passed. Into all orders,
instruction থাকা উচিত ছিল।
So let this be allowed on consent?
আমাদের
Yes, yes.
আমার তো consent
The
আছেই।
addition of party application,
Yes, yes.
Can 1 of 2024. The proposed intervenor seeks to be added as a party respondent to the writ petition on the ground that he is a necessary and proper party hearing. Paragraph, by consent of the parties, the application is allowed. Paragraph, let the allow the alleged intervenor be added as
আপনারা
respondent number
intervening
11
application
in the writ
কিসের থেকে?
petition.
আপনারা কি add হচ্ছেন না?
The cause title of the writ petition be amended accordingly.
হ্যাঁ, আমরা
Paragraph,
আমরা
affidavit of sale.
রেসপন্স হিসেবে অ্যাড হচ্ছে বিকজ
Paragraph.
the order which
WPA
relied upon,
WPA তে affidavit of
যে
sale.
অর্ডারটা জজ সাহেব পাস করছে তাতে উই ওয়্যার
Learned
পার্টি
counsel for the state
writ petition.
respondents seeks to take instructions in
একটাই
this
অর্ডার,
matter.
সেটাই বারবার পাস করছে।
Paragraph, let the matter appear under the same heading on 16th April.
I have reported that.
You want to come back with instructions?
Instead of 16th or any other subsequent date, subject to Lordship convenience.
My lord could have disposed it of any.
I could have, but learned counsel wants to take instructions.
What is this prayer?
I cannot stop him from doing that.
16, I think he has some problem.
17th, next day.
17th.
17th.
Deeply obliged. Dear.
I would request you to go through the orders also, the earlier orders. It will
Yes.
it will help.
এই বইটা।
Yes, next matter.
এটা তো আছে সুপ্রিম কোর্ট। I'm deeply obliged.
My lord, I am for the petition.
Respondents,
And my lord, there are two private respondents. They have received the
Sir?
copy, my lord. Yes, my lord. Affidavit of service. They have received, my lord. My lord, I have challenged
Page 27, the resolution dated 19th of December 2023.
Resolution number 16.
Page 27, resolution date 19/12/2023, and my lord, agenda number 16, serial number 11. At page 28 and 29.
Yes.
Serial number 11. Somnath Banerjee, my lord, resolution, bottom, my lord. The RTA board discussed the matter and decided to issue offer letter in favor of Srimati such and such in route number 212. This is not applicable in my case. 2. In favor of Sarojit Bhaumik and Amarjit Prasad in the route 4545 AB, and rejected other 3 applications as there are only 2 vacancies. Well, without assigning any reasons, without any giving any details of the selection process, they have only cancelled, only rejected my prayer of the application. My lord, on earlier occasion, my lord was pleased to direct at first time to submit a report by annexing the broadsheet. My lord, may I hand over?
What are the reasons for
But
rejection?
matter be further remand, go to remand, reminder back, remind back to the authority concerned.
But I have
all
no
the
objection.
points kept open.
Let them take a reasoned decision.
Yes, yes.
No need of.
After giving opportunity of all
Yes.
the
Yes.
opportunity of hearing of all the parties, my lord.
Affidavit of service. Paragraph, none appears for the private respondents despite service. Paragraph.
18 holo.
The petitioner has challenged the resolution taken by the RTA board in its meeting held on 19th December 2023 .
Agenda number 16.
In respect of agenda number 16.
Yes.
And route may be
On the
mentioned.
ground
Route,
that the
route, my lord, kindly mention the route, my lord.
Yes.
4545 AB.
agenda number 16,
Serial number 11.
which deals with route number 45, 45 capital A and 45 capital B.
Yes.
Stop. Your permit was rejected.
Yes, my lord.
Your application for permit was rejected.
Yes, rejected. Application for permit has been rejected without assigning
By
any.
the said resolution, the application filed by the petitioner for issuance of permit in the said route was rejected, and the applications and similar applications allowed in favor of the private respondents without assigning any reason therefore. The petitioner seeks quashing of the said resolution. Paragraph, it transpires from the resolution that the application of the petitioner was turned down by the authority and applications of the private respondents allowed without assigning any reason therefore. Stop. In paragraph, in view of the above, this court is inclined to hold that the resolution taken by the RTA board insofar as the petitioner is concerned is required to be set aside and the board be directed to reconsider the application of the petitioner and pass a reasoned order
Along with the others.
Along with the others. On giving opportunity of all that.
Paragraph. Accordingly, the writ petition is allowed. The resolution taken by the RTA board in its meeting held on 19th December 2023 in respect of route 45, 45A, 45B in agenda number 16, insofar as the application of the petitioner is concerned, let them decide if
Including all other
let them decide the petitioner's application.
Upon giving opportunity of all
Yes,
the
yes.
applicants.
Directed to কি বললাম sentence টা? Is set aside the board, comma, being the second respondent.
Yes.
Second respondent
Yes,
hearing,
yes.
comma, is directed to revisit the issue upon affording reasonable opportunity of hearing to all concerned, including the petitioner, and pass a reasoned and speaking order within 1 month. It's the board, let it be 6 weeks.
Yes.
Within 6 weeks from the date of communication of this order, comma, in accordance with law. The decision, paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of, what's that line? Hearing matters.
Next, all 5 matters are same, my lord. But it will take, my lord, all 2 or 3 minutes, my lord.
Same order?
Yes.
No, my lord, next matter is not same. I am for the private response.
But
There is a reason.
So please come back.
Yes, madam, yes.
Yes, sir. But I appear for the state lordship.
He'll have an objection to
Yes,
this.
yes.
definitely.
My lord, only my prayer is let the authority submit one broadsheet for my filing a report and nothing more, my lord.
My lord, report is with me.
A report.
Reason is also there.
Reason is also there.
Also there. And my lord, that reason may not be sufficient for the my lord, satisfaction.
My submission is the selection process is completely illegal, not at all transparent, free and fair.
Please come back.
Yes. Yes.
Grateful, lordship.
Only this matter I am appearing here on behalf of the petitioner.
Respondents?
All parties are present.
Who is the respondent? Mr. Naik is appearing in this matter?
My lord, I appear. My lord, that matter with someone too. I concluded my argument. I said, my lord, in 2 occasions. My lord, it's a problem between 2 operators. Now timing is factor. Okay. I'm sorry, lordship. I am here.
I am placing the not safe forward the shortcut method. Although I am holding a permanent permit for the international road on the route Sana to Asansol and also the private respondent. This one he is the operator on the route Chapter to Asansol. Now he made a prayer. I can see the page number 23.
Who is appearing for the private respondents?
Mr. Mukherjee.
You are appearing?
My lord,
Let them conclude the. Yes. Then my kindly see the page number 23.
You have completed your argument, I think.
Yes, I completed. No,
Yes, I find judgment also.
Because 3 months gap. Followed made an application for extension and curtailment. But both are now it will be treated as a variation of the rule. Treated as a new grant of part. Now he made an application for variation of the for extension of the road from curtailment of the road from all chapter to common ground on the roof middle portion. Page number 23. And after curtailment, that it paid for extension from common root to Ketugram. After extension curtailment, route is Ketugram to Asansol. Now can you see the remarks? The applicants present and hearing and going through the case report along with the inquiry report. The case is allowed subject to enrichment from the learned from the local MLA or act. Or I am telling the 1 to 4 grounds, 3 4 grounds. On Motor Vehicles Act is the self-content code. All the authorities mentioned therein are the statutory authorities. They must act according to the permission of the authorities. The state has a general power that may be exercised under Article 160 of the Constitution. Because our Constitution invites the rule of law from government. No, my lord, MLA has no role in the functions of the government. You obtain the certificate of the MLA, it was placed before the Act report on the basis of that it was announced. And so far the Contempt extends that. It is the very principle of variation. You will detail the new ground of part. Now, at first it will apply on the rules. For variation on the rule, if the rule is allowed, then you will surrender the party. This is the procedure. At the same time, my lord, it will allow. Then judgment held by the Honorable Justice Dipankar Dutta. My lord, so far the MLA has no role. That I had got the judgment of the Honorable Supreme Court last of it and I placed. But that the money SLP was allowed, and the cost was imposed to 1 lakh and demanded back to the authority to take a fresh decision. So, my placing my in the last occasion, my lord, I placed the judgment before your lordship. My lord has got it. Judgment of the Supreme Court.
2008, volume 7.
Yes. My lord, SCC. 2008. 2008.
SCC 117. Yes.
Relevant portion. Relevant portion. Page number 8, paragraph 80. Paragraph 80. Maybe. The Act is a self-contained code. All the authorities mentioned therein are statutory authorities. They are bound by the provisions of the Act. They must act within the four corners thereof. The state, although has a general power of control, but such control must be exercised still in terms of Article 162 of the Constitution of India. Having regard to the nature and manner of the control specified therein, it may lay down a policy statutory authorities are bound to act in terms thereof. But per se the same does not authorize any minister, including the chief minister, to act in derogation of the statutory provision. The Constitution of India does not advise functions of the government to the chief minister alone. It speaks of a council of ministers. The duties of functions of the council of ministers are ordinarily governed by the provisions contained in the rules of business framed under Article 166 of the Constitution of India. All governmental orders must comply with the requirements of a statute and also the constitutional provisions. Our Constitution advises a rule of law, not a rule of man. It recognizes that, however, one may be under the law and the Constitution. All the constitutional functionaries must therefore function within the constitutional limits. Now the next paragraph, which is the relevant, paragraph 25, page number 25. It is not a case where the statutory authority was hearing a demand from the public that buses are not flying on particular route. The result whereof the citizens were suffering. Next, this one of 4 appears to be owner of fleet of buses. He had a political connection. Such political connection encouraged him to file an application for grant of permit before the chief minister directly. The chief minister could not have entertained the same, nor usurp the functions of the internal trust authority. Similarly, respondent number 2 committed a serious illegality for forwarding the same to respondent number 3 with the purported recommendations of the chief minister. We also fail to understand as to how an independent constitutional body like respondent number 3 would affirm an epidemic in the state. Its duty before the High Court in response to the rule issued by it was to place the facts as borne out from the record. It was not supposed to take any stand one way or the other. It had no business to defend the state or the chief minister. For the buildings aforementioned, the appeal is allowed with cost. The impugn judgment is set aside at the limited notice was issued. We did not pass any constitutional order which is within the realm of the internal authority. We impose the cost of appeal to Allah upon the state when paid by the National Legal Service Authority, same amount of police, willing it to be open to the National Legal Service Authority to realize the interest. These are settled by the Honorable Court. But another judgment, my lord, single bench. My lord, on the issue of the extension and curtailment. On the issue of extension and curtailment, by placing the judgment.
Please tell me the reference.
My reference number, WP 1361, W of 13, the unreported judgment.
You have not given this earlier?
No, earlier,
Yes.
because my submission. Yeah, in this case, my lord, application for extension and document article. And made it. The petitioner is granted reward in pay. The secretary is not aggravated not here. Thereafter, the RTA, additional respondent in this petition, was title of the petition stands amended here and now. Mr. Devrai, learned advocate appearing for state set notice on behalf of the Joint Transfer of India. The petitioner is the holder of a permanent permit on the International Road. Brahmachandrapur, Beldana, via Korimpur, Padian, Jitpur, Bogni Mode, Amtola Bazar, Poine, Dalitola, Begambari issued by the State Council of West Bengal. It is valid till 3rd August 2016. The petitioner prayed for curtailment of one part of the said route and for extension of the other part. He is agreed because his petition between 19th March 2013 made in the behalf has not been considered and disposed of by the state. Mr. Chakravarti, learned advocate, pays for direction on the secretary ST to consider and dispose of the contained in the completed situation 19th March 2013. Next page, madam. In any understanding, in my understanding of the provisions contained in section 80 of the Motor Vehicles Act 1988, a combined application for curtailment of a part of the road and for extension of the other part thereof is not a permissible by law. Curtailment and extension amount to variation, and variation is permissible keeping the meaning of the route intact. Allowing the petitioner prayer would amount to alteration of the terminal, which is not permissible. The Secretary ST, having regard to the facts and circumstances of the present case, is under no obligation to consider the petitioner application dated 19th March 2013. I find no reason to grant relief as claimed by the petitioner. The read petitioner stand disposed of with the observation that the petitioner shall be liberty to apply before the RTA for a fresh permit on the road Bharampur via Utiberia, Korimpur, Jitpur Ghat, Horiharpara without surrendering his current permit. The RTA shall proceed to consider such application is made in accordance with law within 8 weeks from the date of its receipt. In the event the application of the petition allowed, he shall be liberty to surrender the permit on the state road and to place the vehicle covered by such permit for being applied on the road Brahmachandrapur to Barampur via Labadi, Korimpur, Horiapur. That is this case. The route is my lord. Here in this case, petitioner route, my lord. Petitioner route is Chakta to Asansol. The terminate point has been changed. After change, curtailment and extension route is Ketugram to Asansol, that the one time has changed. But according to section 80, subsection 3, why should? That also for the case of deletion, both terminate will not be changed. Their interest has been changed without following the procedures recognized under the law. The procedure has not been followed, decision has been taken. Secondly, my lord, decision is taken on the basis only on subject, only on the basis of the the recommendations of the MLA. But now, my lord, my learned friend Mr. Nayak, my lord, find its affidavit in the state affidavit, it is admitted. The petitioner submitted the my lord certificate of MLA. Can you see the affidavit was affirmed by my learned friend Mr. Nayak? My lord has got it. In opposition on behalf of the Regional Authority. And got it. Followed the page number 3. Page number 3. Roman 3 at the bottom. It appears that a recommendation from the MLA has already been submitted by the concerned permit holder on 18 July 2017. But the same was lost by the office. The permit holder submitted a receipt copy of such recommendation later, and on that basis, the curtailment and extension which was duly approved by the RT board, right? Its meeting date 17th January.
You're in page 3.
Yes, because
paragraph
3, Roman 3 at the bottom, page number 3 of the affidavit of opposition filed by the
This is respondent number
That is
8.
number 1, 2, 3, 4, 5, 6, 7. That is state response.
Yes.
Taking opposition on behalf of the issue number 1, 2, 3, 4, 5, 6, 7.
Yes. Yes.
So on the basis of that recommendation, my lord, authority, decision was taken. My lord, got it. But it is confirmed that my lord, on the basis of recommendation, the decision was taken, not following the procedural law, which is recognized under the law. Or secondly, my lord, which taken the point in the executive opposition that he has not applied. And see the resolution once more. Can see the resolution, page number 23 of the writ petition. That the decision was taken in respect of the list number 162/9697.
Yes.
According to the petitioner, actually he applied. PSTP number. Affidavit has been filed by the respondent number 8. The respondent number 8, page number 5. Affidavit opposition has been filed by the private respondent.
Yes.
Page number 5, the Roman 4.
Yes.
I made clear for document distance from my road. Document distance from my road in proper way. Therefore, there was that my permit number is 1, but PSTP wants 7. I have not any other permit, save and accept. 65/99. My lord, if it shows that my lord, this modified or my lord, rectified in the next board meeting without rectification. That is the implementation. That I asked the repetition. That has been implemented after 4 years. Now the decision was taken in January 2018. The decision was implemented by the secretary without rectification. That is page number 25. On the basis of that, the timetable has been issued. It has come to Asansol, and the permit also it has been endorsed. It after resolution. Not only this, in the permit, it has been endorsed that the extension cut has been allowed on the basis of recorded of the MLA. That is recorded in the permit. The permit. Now, Lord, my learned friend, in response number 8, is taking the another point that my timetable has already been expired, and also, my lord, my vehicle is flying on another route. But my learned is very much aware that the provision of replacement of the vehicle, and also this timetable may be changed or altered. That in my everyday operation, I have the next page number, I can see my everyday operation. Sorry, in my everyday reply.
Yes.
I have said so. I annexed, my lord, all these documents. Page number 15. This is my copy of permit and timetable, page number 18. Page number 18, timetable. The provisionally approved until further order. That fill the validity of permit. And at the bottom, the earlier vehicle WB of the 464 will be replaced by vehicle number 41. The present vehicle still vehicle supply 4246.
Page 18.
Page number 18. This is the timetable. Timetable is valid.
Where is the earlier vehicle number stated?
Page number 18 in my reply. Middle portion at the left side, at note A. by the secretary, approved, provisionally approved until further order. And also at the bottom, vehicle was replaced. Everything is right. So, my lord, what is my humble submission? There is no scope to implement this resolution. So, kindly set aside demand back to the authority to take fresh decision.
Reconsideration, yes.
Objection. Because this has not taken that much wrong. On the basis of recommendation of the MLA. A petitioner also submitted, or in the ability of the given. To know I have not submitted. Ability has been affirmed by the state respondent. They know on the basis of the report which is submitted by the petitioner, according to that, the petitioner was.
That's all your submission?
Because I already
My lord, I will certainly give my reply after hearing both parties. But I want to clarify only one thing. Because what my learned friend is saying, what was the fact we have disclosed? No suppression. We could have, we could not have disclosed it according to him, but we have. What is the fact we have said? Now, my lord, what he is referring to?
So, but the another thing is, sir, I have forgotten. But actually, when after hearing the matter, my lord was not thinking order. On 23rd September 2023, 22, the vehicle will fly within the territorial jurisdiction of the cosmetic floor.
3
The matter is fixed on 10th November. For a the interim order passed on 23rd, and within 3 days gap, we obtained the council signature from the Pashchim Banwat and also the Beho. Therefore, an appeal was paper without disclosing anything. But last 20 years, vehicle was not flying without consent. Like the vehicle was flying without consent. But we obtained the council signature after passing your lordship direction.
That, my lord, we consider. I am not on that. I will not take anybody's side. If it is decided for, I have no objection, but only one point I must say, that the board, the decision was not taken being influenced by the MLA's recommendation. Where from shall we get it? It was a consequential effect. Maybe it happened, but that was not the basis of taking decision. What my learned friend is trying to impose or impress upon your lordship, that was not the fact. Because your lordship, he referred. No, he referred at page 3, Roman 3, but it starts from 2. It states the application was accepted by the RT board, Puro Bardhaman, by the above stated meeting. The minutes where the applicant is present on hearing and and going through the case record along with inquiry report, the case is allowed subject to NOC from. So on the basis of the inquiry report and of the LA board took the decision, only that was additional term that subject to. And then in the next bit, it is found that the MLA's
provision of such recommendation.
It is not the basis, lordship. It is not basis. I bow down, my lord. That should not have been. I cannot, my lord. I cannot argue for a point which I do not accept. That I am not accepting. But I am saying that the board has taken the decision independently, not being influenced by anybody. But and a condition was imposed later on, subject to.
Where is the independent finding, the independent reasoning?
That is written over here. The content record along with the inquiry report was considered. How it is
Where
the
is the inquiry report?
That is not annexed here, no doubt. Nobody asked for also. I can produce it. That is another issue.
No, you have to show that the board has taken a reasoned decision.
Reasoned decision. And my lord, decision what I find obviously that is in lot of cases. Lot of our cases are taken up. This is the way practice being adopted everywhere for everybody's case. In one resolution, all cases are described. They short note.
But there should be some reason for allowing or rejecting.
That may be very well. Lordship will hear them and pass it.
Let them come back. Yes, you want to come back?
Because if I go on harping, it will mean that we have some. Lordship kindly hear them and.
Her learned counsel for the petitioner. Paragraph on prayer of the private respondent, the matter is adjourned. Paragraph, let the matter
May I
appear
take your kind leave, Lordship?
under the same heading. On
I absolutely. হবে না এগুলো নিয়ে বিষয় করে বিপুল আমি
I'm taking-
19th April.
My lord,
19th April.
19th April, lordship. My lord, subsequently one matter may be called on. My lord, I am taking my lord's leave. I may not, my lordship. They can talk.
Next.
For the petitioner.
My lord,
on the
occasion, my
previous
lord.
occasion, my lord, I
He has
have
completed his
almost
argument.
Not yet completed. At least 2-3 points were left to be highlighted.
Already
before
I
your
have
lordship.
informed the authority, my lord. They are trying to resolve the problem. My lord, your lordship.
This is, my lord,
This
after,
is the difficulty in operation.
yes, operational
yes.
difficulty, because I was forward with the contract, and that contract, the nature of business is such that I have to load, unload the consignments of 23 tons, one at Shalimar and another at Yashwantpur, Bangalore. And that is, at least I require 6 hours of time. And for that reason, Railway Board has instructed, Railway Board through their policy has categorically stated, the policy is there. Lordship may kindly come at page 49.
Since the board is trying to resolve.
Yes,
the
yes.
But nothing, let it be undertaken, because, my lord, may I say one thing, my lord? I am entitled of the free
There
time.
is an interim order and
Yes,
it's
yes.
that for some time. It's till 31st March, I find.
Yes, yes.
Same at the also at the same time, my lord, I don't know what will be the fate of, because I have not given any instruction from my
You are
client.
under cover. You are under a protection.
I am under the protection, but
So
fact remains
let
is
it
this.
be extended for some
Well,
time.
Lordship.
Come back with a, since Mr. Chakraborty says
No,
that.
that has
Yes,
to
yes.
be, kindly record his submission that,
Desirable that
because
shall I record
I
your-
have not, I have
We are
not.
trying to resolve, lordship.
Shall I record your
Yes,
submission?
that should be recorded, my
It's
lord.
not
When the
required.
veracity of
It's not required, my lord. This is your lordship's order, which we are ready to bow down, my lord. Your lordship kindly extend the interim order for a limited period and fix the matter.
Now, my lord, he's wanted to resolve this issue. That should go down in my lordship. Or else, my lord, they will simply say that
You
we will-
must understand this is difficult for the councils. You must understand.
that they normally only a short
Yeah,
date
and
may
this
be
is an,
given.
it will be given.
Because I have completed my submission.
Care of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 19th April.
19th one matter is fixed.
My lord, let it be preponed, my lord. I understand my learned endeavor.
16th, lordship.
Yes, 16th April.
Lordship.
Paragraph, the interim order granted earlier is extended till 30th April or until further order,
Lordship.
whichever is certain.
Lordship.
30th. Great.
Please try to take a
Lordship,
decision in
lordship.
the meantime.
We are trying to, as per your lordship's direction. Grateful to you.
849. Respondents?
Mr. Samant is appearing on behalf of the private respondent.
Private
Mr.
respondent.
Naik is appearing on behalf of the state.
Oh, Mr. Naik has just taken leave.
Requested me.
Let me adjourn it for some time. On prayer of the state respondents, the matter is adjourned. Paragraph,
Short time,
matter, because your submission is complete, I think. You have
Well,
taken a note.
total advice, I should take only 5. Because that is fixed on.
Let the matter appear under the same heading on 23rd April.
23rd April.
Next.
This matter is all about that page 63.
Lordship, I appear for the Union of India in this, Your Lordship.
Who is this?
If kindly comes. Page 54, it starts at page 50.
State.
Madam, I'm
Your appeal.
Madam, our affidavit of opposition.
Now? Have you received a copy?
Yes, madam. They have filed a reply also. Madam, affidavits are exchanged. The whole case is on page 63. Lordship remembers it will take me really 5-10 minutes to. And then Mr. 10 minutes, sir. You have to continue until 4:30 today. Page 63. Madam, Mr. Mitra has assured that he will continue till 4:30 today. Madam, that is a promissory yes He is. Yes.
You can continue it 4:15.
I don't think malediction. Where the licensee proposes, not page 60, where the licensee proposes the establishment of overground telegraph infrastructure over any private property, the licensee shall not require any permission from the appropriate authority.
Only an intimation is required. That was a yes.
And the appropriate authority is defined at page 54.
Yes.
54. It is the local authority, it is KMC, it is the municipality that is the appropriate authority, and here only intimation, while on the other hand, permission is required if it is not, if it's on public land. That is page 59, that is 9.3.
Yes.
9 is the application by licensee, 9.1. 9.1, read with 9.1 is the application, and 9.3 is the fee to be paid. And the maximum fee, it is given in page 65. So far as the fees, I am only restricting the repetition to private property. And when the fees are payable for private property, or the local authority for public property, or as they call it, property of any appropriate authority, which is a more common payments on those. That is the maximum fee. For that, we are going to take this. And now the state government has made a guideline, which is at page, starts at page
100, I think.
Yes, it starts 100. Yes, it starts at page 71 and 103.
Yes.
103, Lordship. 5.
Yes.
No person shall erect, install, or establish telegraph infrastructure without obtaining prior permission from the appropriate authority by applying through online process. It's no difference between private and public. And also, can you see 6A? 1. Application for all telecom infrastructure deployments. If an applicant licensee intends to seek NOC or clearance or permission to install mobile tower or base tower station or seek permission for laying optical fiber cable, then applicant licensee is required to fill common application form 1 along with the prerequisite documents to be uploaded and make an online payment based on the proposed work. Proposed work terminal by referring section 8, fees and charges, to a unique portal. And Lordship sees then 6I, AI.
Yes.
In case of installation on private property, the applicant shall upload the following documents. These are, if they say, Lordship interprets only this, well again, I have noted. But if 6.1 has to be also accompanied with 6A, fees and permission. If it's merely 6.1, applicant shall upload the following documents. 1, 2, 3, 4, 5. It can be on the scope of intimation. They may require these documents.
It again talks about approval.
Now, Lordship Kelly takes their opposition once.
Yes.
There at page 5 kindly comes to page 5.
Yes.
H. Subparagraph A. It is stated that that requirement of uploading documents in cases where the installation is on private property is mentioned in clause 6A(I) of 2023 guidelines. The documents are sought for are in tune with the documents as mentioned in second provision to clause 10. As noted. Lordship kindly clarifies this and we are over. That is their stand here that this is in tune, but 5 and 6A can't apply. That's page 103. Prior permission and 6A. Somebody who seeks NOC or clearance or permission, he has to do this. That can't apply because of 10B. And they are themselves, they are accepting 10B, they have no option but to. And they are saying that is one is in sync.
H actually they've accepted it. But H they have accepted it. That only documents need to be
H
uploaded.
they have accepted. So H, what I said, I have no difficulty, but the last 6 lines of H is again.
Yes, yes.
The
They have
permission as sought for has to be considered in light of the powers exercised by a local authority in granting permission for setting up such mobile tower. But local authority is defined in this page 54 also.
Yes.
That is the local authority, which is also the local authority which they are referring to, whether under the policy and the rule, same local authority. So not that there's some other authorities who's, so this is the local authority whose appropriate authority, and that is the distinction. Appropriate authority has some other powers so far as private land, only to receive intimation. That is proviso to 10. Now, first part of paragraph 8 is absolutely fine. But the next line they say, that goes contrary. And Lordship, kindly remember, last day Mr. Anand Chakraborty had relied upon a Supreme Court judge. Half-heartedly he relied upon it. Half-heartedly. but let me show this. You know, Ahmedabad Municipal Corporation, 2017 3 SCC 545. What I SC print out. Been introduced when in 2000 with effect from 17th August 22. Before 17th August 22, it was all the same. Now, secondly, Lordship will find what is this judgment about? Actually, can you see the first paragraph of this judgment at page 554? Paragraph 2, second paragraph.
Yes.
This group of cases may be conveniently arranged in 4 different categories. The first are the appeals arising from the judgment and order dated 24th so passed by the Gujarat High Court declaring 145A of the Gujarat Provincial Municipal Corporation Act as ultra-virus. And on that basis, interdicting the levy of property tax on mobile tower. High Court by the property tax on mobile tower. High Court by the impugned judgment, however, took the view that the cabin in a mobile tower in which BTS system, details of which are noticed below, is located, would be a building and therefore exigible to tax under the Gujarat Act. The state government and the different municipal corporations have challenged the first part of the order of the High Court, whereas cellular operators have challenged the latter. So it was whether permission is required, sanction is required for levy of property tax on mobile tower. Levy of property tax on mobile. Now, Lordship kindly notes here, Lordship kindly notes here, what is today we are challenging is a guideline published in exercise of executive power, page 100. Page 100 is executive power. Also, if it was municipal corporation, they were seeking to levy municipal tax, then the provision of section 171 would come. This is not property tax under the Kolkata Municipal Corporation Act or West Bengal Municipal Corporation Act or West Bengal Municipal Act, but I am just showing as 171.
86, page 86. Page 86.
For the purposes of this act, a property tax on land and building is as determined under this chapter shall be imposed by the corporation.
Yes.
This is not, this will be under 171(2). For any building, the property tax shall be equal to a percentage of such annual value of covered space of building as determined under section 174, subject to a minimum and maximum limit of 12. Then 174 Lordship takes us to determination of annual value. For that, if at all anything is payable, municipal taxes, that is under the KMC Act, that determination. So this is not by this guideline. And if at all this was a levy, this was a regulation made under the KMC Act, then Lordship will find 435. What is the way of regulations are made under the KMC Act? If they want to argue, though this is apparently not so, this cannot be a regulation. Because you see 435
Page 254.
of the KMC Act.
Yes.
435.
35 is for non-residential purposes, yes.
Subregulation 4, subsection 4. The corporation by regulation shall by regulation determine the fees to be paid in respect of a municipal license.
You're on section 435?
435 subsection 4.
Yes.
The corporation shall by regulation determine the fees to be paid in respect of a municipal license. Granted under subsection 1. So if they want to levy a fee under the KMC Act, whether validity of, I doubt it, but if it was, then it would be a regulation of 435(4), which has to be read with 602. It has to be placed before the assembly. This is a different.
My lord, I am assisting Mr. Mitra. My lord, Mr. Mitra may kindly also show section 602.
Yes,
of
that's
the
what I'm
KMC
coming.
Act.
That's what I'm coming to. 602. Section 602. 435 subsection 4 takes us to 602.
Yes.
And 3. Power to make regulation. The corporation may make regulation not inconsistent with the provisions of this act or the rules made thereunder for discharging its function. And 603. Condition proceeding. To making. The power to make regulation under this act is subject to the condition of the regulations being made after previous publication and to the following further conditions, namely, a draft of the regulations shall be published in the official gazette. The draft shall not be further proceeded with until after the expiration of a period of 1 month from such publication or such longer period. Then, or not less than 1 month during such period, a printed copy of such draft shall be kept in the office of the corporation for public inspection, and any person shall be permitted. Then D, printed copies of such drafts shall be obtainable by any person. And then 604, no regulation shall be made by the corporation that shall have any validity unless and until approved by the state government. And before approving, there is also a procedure laid down. This is not their case in the opposition, I must say. But just in case Mr. Chakraborty argued that this is a KMC Act levy, this is not. And I do not think he's got any judgment post 22 August interpreting 10B. And that is all I have to say. But
Next, when will you come back?
This one. My lord, only thing I just indicate, my lord, I should not. Previously, they had filed.
Come back on the next.
No,
one,
just
because I
one
have to
sentence
leave.
because my lord, then because they had filed a writ petition, taking a before this on this the same company, taking a different stand, saying that I am bound by these guidelines, and I'll show the orders have been passed. The same company.
That is included in your.
No, my lord, that is it's a court record writ petition. Court record.
There can be a
No estoppel. I'll show the conduct. My lord, the conduct is also. The court, my lord, I'll show my lord, where they have said municipality cannot charge me. This fees has to be charged by this portal, through this portal. I'll show this. Orders have been passed.
by the same company. My lord, if this is a case of my lord wants me to put this on affidavit, I can put this the writ petition because
I've got a copy, Lordship. I will not be technical. I can assure Mr.
Since it's a writ petition, you can just put it.
and the orders passed in the
Stubble against law.
But
হবে?
learned counsel
হয় না
for
স্যার
the
স্টুপেলিং স্ট্যাটিউট কি করে হবে
paragraph, let the matter
Conduct
appear
to that.
under the
Conduct.
same heading
কিছু তো বলতে হবে
for further consideration on
All of take all the judgment.
দুটো আরো জেরক্স করে দিন অরিজিনাল
17th April,
স্যার 17 লিখুন
17th April,
মানে সাবজেক্ট টু মাই লর্ড my learned senior friends convenience
Whenever, Lordship,
17th.
I'm grateful. 3:30 p.m. Lordship.
Yes,
But Lordship never does it. But
it starts from 3:30, so it will not be difficult.
Partner, I've tried many matters. I have a whole
I have exhausted my list today, in fact. Group 7 matters are not many, so it will not be.
I'm grateful man I'm grateful
But the one- she's cool. Can't put it like this.
Check it.